but be strategic. Be strategic. Because your category A, it's not something easy. But osobola okujja n'okugamba okay, nina okuyita category B with A. Because for trial advocacy, abamu kumanyiza mulina mu muntu already. Okay? Muzimanyi weebuze nyongerako mmeka. Njagala 5 kola ki? Kati instead of 5, yongerako 30. Because the final paper is out of 14, so yongerako 30. Already obo. Okay? Already oli mu 8. Eyo A. Man kati nina A. Ogamba, what else do I need to pass? I need professional conduct and legal writing. So now at least 70. A or B. Okay? Why? We are looking at ways on how you're going to raise your CGP. Category A to raising your CGP. So Wobaland, okay? Category B. Ngenda kufuna A zange 3. CGP very down. Already olimu 3 point something. Okay? Kati ogenda okugattako zino ng'oyingidde fonga balina first class. Okay? Now oli ku first class. Naye first class tugenda gibalira ku category A. One of your predecessors, she had an A in legal practice skills 2, that's accounting and taxation. She had an A in corporate governance, that's category C. She had an A in trial advocacy. Nazigenda nga 65 ng'olwedde CGPA eraga first class naye ng'agudde legal writing and professional conduct.
Legal writing and professional conduct, one paper.
It's one paper. Can give a paper at the good. The way Allah made it and they added them marks. She passed. First class day for 9. Kajagenza kuddamu okebera foto ng'ayinako. Yambula na kanso simanyi. Yasoose ng'akaaba ng'aziraba marks azirina naye ng'ali kuba supplementary. Yeah. So yalina 45. Okay? Okay, kati bagenda mwongerako from 45 ng'ayingidde 6. Ayitawo bayongerako category B. Okay, so you see bw'otuula n'opala because passing LDC okusoma ennyo to the maximum, it's not the solution, but they've always told you that at LDC read smart. Ngomanyi that I'm taking this direction. Leave alone the pressure that is around. Pressure is ours. That's the naked truth. But how are you condensing that pressure? So you sit, put your efforts in this at this point. Why? The final exam, you don't need to read as much as you think. This reading we are making here, are you going to read this land we are going to read today when you're going for end of term, end of year, the written exam? Anything. Okay? So make sure you are strategic. Okay? Don't risk over you're not thinking. So be smart so that you get to know that this is the way forward. Because all we want is to leave this place and go in peace.
Not in pieces.
Okay? I feel very comfortable when I enter court. I find someone I know. Okay? It's the same way you will feel when you see your colleagues around you in practice. It hits different. Okay? It hits different. And it is the best. Okay? So make sure you read smart. This point, category B, we need A and B. Yeah, how are we going to get those marks? Okay? These orals, because naturally orals are out of that, but you can get a 25. So that means because they're going to mark you you can get a 25 in that exam of oral. If you have 25, okay, you're going to get your IS and life will move. You already know that, okay, we need what we need in category A is a certificate like this. But my dear, go out there, all those prominent lawyers, you still got, yeah, or it's not easy. But people have passed the bar course and you can also pass. Okay. She also passed.
You can say it is difficult.
Okay, so we are going to make it. That's the part you need to believe. So now, category A, we basically have how many units? 5. So when you are preparing, okay, at this point, I need energy in corporate and commercial. At this point, I need energy in civil. At this point, I need energy in land. Okay? It's because now you guys, we've been doing farming. Okay, we've been rotating in family. So that's why I'm saying at this point, I want us to polish corporate, land, and civil. Because those cost units, they look to this. When you look at land, looks slight, but it is a bit wide. So I want us today to agree on that topic 1, as you saw it on. We already did it, okay? But the more you do things, the more you appreciate, okay? And the way we are preparing for it this time around is a bit different, because what we are aiming at to understand those hidden things that we need, okay, before we do anything. Okay. So I've always told you that land is one of the simplest units to pass. Reason: the laws in land are static. They rarely amend those laws, and they are not procedure course units. So when you look at land is not a procedure course unit, it's a substantive law. Substantive laws you can even cram and pass, but a procedure course unit, you say, this can go by notes of motion by Jameson. What should I do? Because it's a procedure course unit, any lawyer can have a different answer. But in land, if it is a fraud, it is fraud. If the question requires transfer, it is a transfer. It will never change. It will never change. If the question requires powers to sell, it will be powers. But in simple, I can go for setting aside consolidation. You have a consumer question in remedies here. But in land, that will be always the same thing when it comes to corporate and commercial. Those two cost units are related, they don't change. So you can tell that if the question wants a company, it can be partnership, never. Either one research for or what it is for. Or Kiriza Novanga good day. Okay. During our year, I had my best friend was called Mwonge Muhammad. So we used to read together on a daily basis. Ngachamani Ngachimani. Ngatusoma at the same pace. To come to fire corporate. Never to Waula. Natulam library, he was in the auditorium. So upon reading the paper, because I always tell you, the paper has an answer in it. We read it, our number 1 required a company, but the facts are confusing. You could go for joint venture, you could go for a partnership, never take only one line like this. They said they said they don't have capital. Okay, then they came down and said, draft that one document that can help them get capital from the entity. I got that, okay, they want a memorandum. And from the memorandum, they want that clause of share capital. I see how we are going to break the shares and we sell them. Nenkola company. Tukula msiramu nakala nenegezako ndowooza nanate kajja nga ndaba kali ku part B. So part A said that advise the parties on the appropriate business venture. Then part B, draft the appropriate document that will aid them get capital from the very. Katia yakoma ku part A. So me, I read the entire question, the answer to part B. Because what do NTU Nesolo call in a company or capital Mojeko company? Now this is a company. Nenzira you are Neso Kakola company, Nens Jangi, some visa. Nanamsia, that was a partnership. There was some question that is most cases. I'm saying Nzikiriza. So Ngovamos taking it positive, but simple. Nina kula ngani sabi review or revision. At least on now we answer this. Wait next time. Mugina tula mu ai enga muyaba. Buyo makole answer ya jao. Atenga zonango. Kaligoyebu zentu fiyedwa. Okay, but in corporate the answer will be always that. The same thing in land. So today when you are looking at land, just know everything in land is the same. It does not change. So basically why we are here today, we want to re-appreciate and try and turn around what we think can't be turned around. Anyone with a question bank for orals? Okay, so our topic 1 in land transactions, when you look at the list of covered topics, it behaves in a very funny way. Okay? When you look at land, the way they gave you those topics, okay? They're around 9, non-so. But those 9 topics, they have what we call sub-topics. So those sub-topics, they are what we call learning outcomes. Okay? Because if you realize how many weeks do you have of land? The land week you did, it was week what? Okay? So you have 4 weeks. Okay? So that means your work is supposed to be divided into 4 weeks. So the first week, you see those subtopics? They are the learning outcomes. Workshop 1 and workshop 2. So that's why I've been telling you that always when you are dealing with the workshop, take your time and ensure that you cover the learning outcomes. Don't get a bit of pressure at the end of the week. But you guys have been going for what we call tasks. Tasks are not exhaustive. Okay? They are not exhaustive. That's why we took a Friday. Now we won't get a Bolava star. Nenga wakola bomulina na ye. That one's take it day walk. Okay? So they reproduce all the learning outcomes. So we are going to look at the learning outcomes of week 1. So your week 1 dealt with what we call interests in land and tenure systems. Okay? That was your very first workshop. But that workshop stretched to topic 2. Okay? It's straight to topic 2, what we call land transactions. Because you did a sale transaction in that week, so it extended a little bit to topic 2. Okay? So now, when you look at that list, it has the following topics: interests and dealings in land. Whenever you read it, now see this topic. How do you get to know what I'm supposed to read? It says interests and dealings in land. What does this mean? First, appreciate the interest you have in land, and then after, see how you deal with the interest. That's why it is called interest and dealings in. Can you deal in something you don't own? First, understand what interest do I own in land, and how can I deal with it. So that was the first thing to appreciate in week 1. So ask yourself, in which one you were expected to first understand what is land? The first place, because you can't deal with a subject matter you don't understand. Okay? Then after appreciating what is land, then you had to go and deal with interests only. Okay? You ask yourself, what are the different interests that are owned in land? That means you have to look at what's called legal and equitable. Then after the interests, okay, then ask yourself, what are the rights? Because you may have an interest. Interests are different from the rights, not so? Once you may be having an interest when you don't have right to say. Okay, that is different. Okay, you may be owning land, but when it has an encumbrance, which bars you from exercising it, you get it. So you should be able to tell, is this an interest or it is a right? Okay. Then after understanding the interest, and then ask yourself, how best do I protect my interests in land? That's why you looked at caveats, the different types of caveats. So you ask yourself, how do these caveats operate? Okay, that's the other things you want to go through. Then after, ask yourself, okay, if I've learned how to protect my interest, what evidence can I show people that I have an interest in this land? That took you to what we call certificate of title. How you interpret a certificate of title. If they give it to you, can you interpret a title? The different entries, and that question in Oros, you had PAs talking about it. Okay, I'm telling you here, 10% you have to get titles. It will be either lease, freehold, or mile. But ikuwe ngeriko mortgages, bagambe go to the encumbrance page, start interpreting. Okay, they give you when it's a lease, you have to interpret the title in its entirety. But why? Because a certificate of title is conclusive evidence. So now that's how you're going to prove people that I'm the owner of this land. You see, I have been a certificate of title, but you understand the title you have. Okay. Then after that, remember you should now you're dealing with interests. So then after an interest, ask yourself, the interest I have, I'm owning it under what tenure? Is it mile? Is it freehold? Is it customary? Okay. Is it a leasehold? Then after looking at those tenures, understand each and every tenure has its own legal restrictions. That land, okay, is basically held in mile. Mile tenure applies in certain regions. So you think you can come from Uganda, you go and enforce the mile tenure in Imbarara? It can't. Why? It is restricted. It has its own restrictions. So like you can enter the panel, they give you facts where someone wants to buy mile tenure here in Uganda. Okay? But it has its own restrictions. So that means wherever you're coming from, you have to adhere to those restrictions. Because for it, it's own subject to customary interest. That is the law regarding mine. So you can't change it. You either compensate me or bond the cow. Okay? Then you look at the lease interest, the leasehold tenure, how is it dealt with, what are its legal restrictions. Then after that, because these tenures interlock each other, you have to look at how we transfer from one tenure to another. You understand how we transfer from leasehold to freehold? Which type of lease can be converted? Okay, can we convert a lease from mile to freehold? Because the law says you can convert a lease to freehold. You ask yourself, which lease can we? They'll give you facts where the lease was granted on mile. Gojichuso jise mu freehold. Mile is, that's what a mile is independent. Okay? So then after that, ask yourself, do you know how to convert from customary to freehold? Do you know the essence of that process? Okay? Do you know the duty of a recorder? The difference between a recorder and the registrar? Do you know the powers of a registrar and his or her duties? Can you tell? Because up we have certificates of title. Then this, so who issues the certificate of title and who issues the customary certificate? What's the distinction between a registrar and a recorder? You can just enter the pan, they tell you can educate us on the recorder. Literally, they are telling you, tell us the process of conversion from customary. Okay, you show that you talk to at a duty of a recorder in that process, or they are literally telling you that how do we convert, how do we obtain a customary certificate, but they won't ask you that question directly, because if you know that a recorder only operates in circumstances where we convert in customary to, and okay, let me talk about this recorder. In that line, and when you even comfort, okay, then after that, you look at what we call general restrictions to land transactions. Now you've understood what you own, okay? You have your tenure, the interest you have, okay? How you can protect it, and the proof you have, okay? Then that means you are ready to enter into the dealings. But before you enter into the dealings on land, there are things you should put into consideration, what we call legal restrictions. These are general, that in each and every dealing in land, you should put them into consideration. So ask yourself, we have minority age, we have capacity, okay, people of sound mind, we have citizenship, the tenure itself. You look at all those restrictions, okay? Then after, you ask yourself, okay, what are the different dealings in land? Then you start settling down that, okay, we have the following dealings. That one, the sale transaction. Ask yourself, do you know how to structure a sale transaction? Okay, that means you can sell a legal interest, you can sell an equitable interest, you can sell mile, you can sell a freehold, you can sell leasehold and customary. Okay, so if your client wants to buy mile, can your client buy mile? If your client wants to buy lease, can your client buy the lease? So you ask yourself, can we sell? Then you come back, okay, so before we enter into a sale transaction, what things should we do? Okay, then that will take you to what we call due diligence. What kind of due diligence is required before you enter into a sale transaction? Okay, what documents are required? You're buying from who? A company or an individual? So the due diligence will depend on the person you are entering into with this transaction. When you see the questions after, bakuwa question ng'ogiraba ng'ogiwulira or answer, however, you want to say something, you feel it, but the whole bringing it out becomes a problem. That's what's going to take place. They'll ask you, they'll give you the title. They say, cancel. You will see the title that it is a freehold title. They tell you your client is to deal from India. Proceed, he wants to buy. Now we get that he wants to buy. Okay, this is a sale transaction. So you are an advocate. Okay, ask yourself, can Sudhir buy freehold. Okay, what options can I use for still to buy this land? Now we start thinking, okay, what legal restrictions that, okay, citizenship. Can a non-citizen buy mile? You cancel that out. But they also stick on the position he wants to buy. How can he buy? Let me advise him to make a company. Let us make this company citizen company so that it becomes a citizen. Let us buy freehold. But again, before we buy, what are the conditions on this title? Okay, if it is restricted for residential, do you think we'll still come to do residential here? That means it's supposed to be commercial. So calico restriction. So can you go for it? Solve that problem as a prudent advocate. You cycling within your head. Okay, you have to be a fast thinker in orals. You have only 5 minutes. Once they ask you, they press the timer. So when you understand that I'm dealing with land, it is a land transaction. They can't give you a question when it's not a transaction. Of course, that's what you should do. Okay? They'll give you a transaction, but this transaction, you have to effect it by all means. So whenever a question comes, start breaking the question even before they start asking you like this. Start thinking of the answer. Again, don't marry a question. Go take the topic, but go get a sidika. You wait for this person to conclude the question. Okay, again, the marry. Already. Now where are the jetandikide? Kadogena kwansalinga. Otanko gamba. Pardon. Sande. Gatandiko ku. Omyuka amasola batayimwe edduka oyingire dasikezi tonna yogera question etambula time olukaaba kaka stop. Second question, already you've not answered, you're in a zero. Are you going to maintain the momentum? Yeah. Okay, so when you enter orals, the format we are taking, it should be in your head. Okay, when the question is being asked, whether it is which course you need, that is the way forward. Think when the question comes. This is an opportunity we have to pass the backwards in orals. Also, an option at that, no camera, you. Okay, yes, those guys are prepared before council. Okay, once you mention the question, the answer like this, okay, I can stop. Next question.
How much is supposed like to answer to explain?
You speak until they stop. Because you will keep quiet, but one of the answer. Okay? No, because once you tell that it's proud, don't just start. Get that introductory of explaining, showing that now you know the law. Okay? And now when you are meandering around, once you mention the answer like this, you don't tell this talk. Next question. Go man, okay? Are you sure? Are you done? You've answered, but not their satisfaction. Go man. Speak. You will end up speaking the right answer. Okay? So once you keep quiet, you don't have a mark. Okay? So now let's get to our topic 1. Okay? I'm very sure we all have an idea. Okay? On the first topic, we have that idea. Okay? And we know what to do. But the reason why we are here, we want to turn that idea you have, because you have the touch of the law, but not the practical part of it. So we want to first go through these things sharp, then we get those questions. We turn them into practical so that you start knowing how we add up things when you are answering. Okay? So now, first things first. Even if you don't write, okay? Because at this point, your head is key than the book. Ebyekitabo byaweddeyo. Togendagana kitabu mukolo. Okay? So you not just a few things, okay? But listening and understanding is paramount. Okay, so first things first, the quotient is known as land. What do you know? That is called land transactions. When you look at this, land transactions, okay, it's called land transactions. That means everything you're going to do in this unit is a transaction. That's the first thing, is a transaction. Your first week was introducing you to what we transact in. What is land? So that means your first workshop 1, basically wasn't the sale, because the sale was in workshop 2. That's when you drafted the sales agreement. That means workshop 1, you had to understand what is land, what you own in land, how do you own it, how do you prove it. That was your first workshop, because you're going to be transacting in land. So that means from the first week, everything you've been looking at are the different transactions. Okay? So, first things first, what is this land we are transacting in? Okay? And what we own in land? At LDC, they don't teach the definition of what is land. Okay? They don't. But you have to understand it, whether by force. Okay? The presumption is you understood those things that undergrad. At LDC, what they emphasized is what we call applicability of the law. So the presumption is the reason why it's not called land law. They don't teach land at LDC. Land law is at under. So that means you left undergrad when you have appreciated the law regarding what is land, the different interests in land, the land tenures, how we protect land. That's the presumption. So at LDC, you come, they give you a transaction, you apply the law, you appreciate that undergrad. But family, they don't know that at undergrad, we didn't understand the law. So the reason why, the first thing why the backwards is hard, we do 2 things. We appreciate the law and apply it. And the mistake we do, we first want to apply what we don't understand. That's the first mistake. So now you're going to enter into orals. You want to apply the law, which you don't know. So that's why what is in order 53 of the civil procedure rules. Because of that challenge you have, minor orders in the car, the civil procedure rules, you will start answering. Not like that the last order is order 50. Once you open your mouth like this, they will just ask you, have you been at the backwards? Do you know the law? That means you don't know. So the first thing, ask yourself, do you know the law related to what is land? Okay. How much do you appreciate it at undergrad? So at undergrad, when you are dealing with land, you have a topic known as fixtures and chattels. That is the topic that was introducing you to what is land. That's why currently they tell you this kind of a property, it has houses. So ask yourself, is the house part of land? That's why you find it difficult in differentiating between a license, okay, tenants, and leases. Why? They gave you people with kiosks that are not attached to land, okay, and you ended up calling them tenants. A licensee don't have exclusive. Your things you use on land are temporary. They are called, are they fixtures or chattels? Chattels, okay. So that's why you got issues in leases, licenses, and why your first week of understanding what is land was a problem. But they will never tell you that this is what they want. They expect you to read smart and mature. So first things first, when you look at the Land Act, it defines land. Is it the Land Act or the RTA? But I'm very sure I don't have that definition in your book. I'm very sure. Okay? I'm very sure. I'm at the Regina. Go Okay? So it's defined. Is it in the RTA or the Land Act? RTA, the interpretation section. Okay? These are the section 2. And so 2 theory. Copy the act. Okay, I'm just going to verify certain key provisions. The rest may have become this. Okay. Section 1. So when you look at section 1, paragraph I of the RTA, gives a definition of land. Okay, it says that land includes usages, tenements, and hereditaments, corporeal or incorporeal, and in every certificate of title, transfer, and lease issued or made under this act. Land also includes all easements and appurtenances appertaining to the land described therein. What does this mean? Once you have the title or your title, whatever is described in that title is land. All easements and everything that is land. Non-so? That because it is land. Okay? Even if it is a boundary, with title if you've been with titles, okay, eno ye main kati gokkirira bwoti olaba wano kati gweyo plot etandikira wano lino lyekkubo lino ligenda wako, because everything described in the title is land. And when you get those one titles eziraga ennyumba, okay, nga bakawaka sign kati, because everything that is described under that is land. So when you go ahead and appreciate what is land, that's how we come to go back chattels. So the general is everything attached to land is land. We only look at the degree of attachment and the purpose why you have put that there. Okay? So if you are dealing with a fixture, the degree of its attachment, okay? If you look at the degree of fixation, how is it fixed on land? It becomes, when you remove this house, it will damage the ground. And so its degree of attachment shows an intention that it should be part of land. Now, he's selling this house, okay? They will wait how you describe, okay? Some of you will say the matter of sale of house located isn't house land. So they will expect you to say in the matter of sale of developed land. This land is developed with, okay? That's what they will expect, but you will not learn why they have given you facts where it has a house. You are selling land, but with a fixture. It is land. Okay? So expect, if they tell you to draft that argument, are you going to say in the matter of sale of land? Show what is on that. So the difference between selling vacant land and selling land with developments, it has to be shown that this land has fixtures. Okay? So you'll enter orals. They test that. Okay? because because maybe when you've been in practice, you can tell that if you are making an agreement for sale of land with developments, this is how we structure it. There you can pass. But when you are just playing, but they will be testing your first, do you understand what is land? But you can't tell. Okay? Then when it comes to chattels, the degree of their affixation doesn't show that they are supposed to be part of land. So they'll give you facts. You look at them as tenants. Okay? Remember that work you had where some people are supposed to be vacated on land. You have to appreciate tenancies, the different types of tenancies. Tenants at surface. They gave you a lot of tiny facts. Okay? Someone who was using the corridor just by now at table at Miracle Suites. Okay? Someone, you get the difference now. This person has a table. KCC where they are using up an apparatus. That is not part of that building. So I'm not responsible. Okay, it's not part of my building. You had those facts, but they were testing. You understand fixtures and chattels. Okay, and what interest does that person have in that? I now can this person claim that's why KCCA knows. That's why they are enforcing everyone to be enclosed in a building. That's why they are fighting kiosks. You either have a permanent kiosk which is affixed in land, because once it is a fixture, they will go for what we call ground rent. That's why they're saying we don't want kiosks, because a kiosk, how are you going to charge that person ground rent? It is in there. So they are fighting it because they want buildings, they want fixtures on land so that you pay ground rent. Someone with a fixture, okay, and the chat, they are different. So someone with a chat can't pay ground. So they are fighting that, but that is the essence. So now the presumption is, you know, that everything attached to land, depending on the degree of its attachment, is land. So now ask yourself, when it comes to this land, what do you own in this land? That takes us what we call interests in land. Okay, how many types of interests do we have? We have two. That is legal and so let's start with the legal interest. Legal interest in land okay, so a legal interest in land is an interest which is registered. Okay, an interest which is registered. Okay, an interest which is registered. When you look at section 54 of the RTA, no instrument is effectual until registered. Okay, so that's why when we out there in practice, after nakola transfer, why? They are fighting for the legal interest. Why not equitable? Because you know, and a legal interest will always supersede an equitable interest. That's why debate at the end. Ask they understand it better. Okay, why? Protect this legal interest. It is protected. Okay, why? When section 54 says no instrument is effectual until registered. So the interest you have, is it a registered interest or not? Okay. Then after that, when you look at section 59, a certificate of title is conclusive evidence of ownership. So that means once I appear on the title, number. Okay. Over the it is okay. It is okay. customer and little title. Remember, even why? When they are compensating someone with a legal interest, you get it? Why? A legal interest. So under such circumstances, ask yourself, how can someone get registered on land? Okay, things that bring about what we call a legal. Now, on that very point, that section 54, it uses a certain word, okay, that no instrument is effectual. So what does that mean? We have instruments that affect a legal interest. Before even we go to the other things, ask yourself, what are the different instruments? That question is common in land. Okay, stands give us 6 instruments in land transactions. Now, okay, so the first one is, so an instrument is anything that affects interest. Okay, the instrument you use to transfer the interest you have in land is what we call an instrument. The first one, the mortgage deed is the instrument, because a mortgage deed gives the mortgage today. Okay, you get it. It gives the mortgagee an interest, so it is affecting your interest. Then two, we have a sale agreement. Okay, a sale agreement also confers an interest in land. Another one, we have transfer form. Okay, remember, once you sell, you give this person the power to transfer your interest. Okay, yes. Then another one, we have transfer forms. Once you sign for the transfer form, you've given me an instrument transferring your legal interest. Okay, then another one, we have a caveat. It affects your interest. Once I lodge the caveat, okay, then another one, okay, we have a lease agreement. Use the word agreement. A lease agreement. Then we have what we call a gift deed, because the transaction is called gift inter vivos. The document is called a gift deed. Because if you pass the barcodes, that friend of mine I was telling you, Mohammed, after us leaving the barcodes, seeing that what now fire kata. Now I'm saying, okay, why? Once your father becomes happy, we say purpose. What do you got one again? Watata wandika ngotandika kubira kuba sidiru natandika kuchumia one again. Because you get it, because you have proof that this interest was transferred to me. Then another instrument. Yes, some of it still can't. Okay, even a sublease is a lease. Yes, letters of administration and the probate. Grant of probate, letters of administration is omeka. Waliba kusaba inzo kusaba kumi. Okay, kati wogamba letters, oina answer meka deeds. Okay, another one. You have probate. Okay, probate covers the will. What else? Okay, mutation forms, they are not registered. Okay, it's not registered. You can say, actually, you can put a chart on the car, because that was under mortgage, but you put a chart, nobody car. Okay, so now, okay, we've seen the different instruments. Okay, so now when you look at those instruments, you know that most of them are registered. They appear on a title, and even powers. Yes, even powers of attorney. It's an instrument. Read the case of Frederick Isabe versus Orient Bank. Okay. So now you've known what is land. Okay. Now we are on our legal. So showing the instruments that affect the legal. But now, how does someone get registered on the title? Because when you're talking about legal interest, something that appears on the title. One, you just come in these very instruments. Okay? It appears on the certificate of title. It is a form of legal. Okay, you get it? The first one is letters of administration or grant of probate. Because if not talking about title, it becomes conclusive evidence of ownership. Okay? And then another one, upon payment of full purchase price. Okay? Upon payment of full purchase price. Okay? Then another one, title by possession. Don't talk about those differentiate. We have section 29 of the Land Act, which talks about lawful owner and a bona fide occupant, someone who occupied that land for what period of time. So once the 12 years expire and you apply to get a certificate of title, you change from equitable to legal after obtaining what we call title by possession. You get the difference, okay? Because here you have proof of ownership. Whatever they call base, you don't have proof. Now you fall under section 20, section 59. You are registered now because you have GAM. Okay? Then we have a lease. Okay? We have the lease. You see that the lease, it also reflects on the title, not so? Okay? So, and you can get proof. You have what the leasehold certificate of title. Okay? Yes? You can sell a legal interest. Nature pattern. Then they sell. Okay? That is it. Okay? Do you have any other way of someone can get registered on the title? Yes? Yes, a trustee. Okay? Remember, a trustee becomes a body corporate, okay, with capacity to sue and to be sued. Okay? So now, do we understand what is a legal interest now? Now let's go to equitable. Okay? Equitable interests. Unequitable interests, these are interests that are not registered. Please differentiate between interests and rights. Okay? You get it? Because we may cite some things, we know we are longer. You get as an interest when it is a right. Okay? Yes. So we are looking at what called equitable interest. So you say that an equitable interest is an interest that you can't register. You have it, but you can't register it. That's why they will say a legal interest, okay, is against the entire world. But an equitable interest is against you. Okay? It's like being in an illegal relationship. Okay? What if they disappoint you and you start crying? Okay? How could you tell your man, nah, on what basis? But it's different. You get it? So that means if you are in an equitable interest relationship, keep quiet. Let them break your heart peacefully. Okay? And in pieces. Okay? So leave those with haram to be in peace. Okay, so now when it comes to equitable interests, these are interests that are not registered and they are enforceable between parties. Okay, so the first one, you go under section 29 of the Land Act. Okay, it says, section 29 of the Land Act, it says, meaning of lawful and bona fide occupant. So the first type example of equitable interest is what we call lawful occupants. Okay, when you read the meaning of lawful occupant, it says lawful occupant means a person occupying land by virtue of a Busuru and Mvujo laws. When you trace back, okay, in Buganda, the essence of Busuru is, that is the typical word of trade in Buganda. Okay, Busuru and Mvujo, it was a payment that Baganda used to give Kabaka to recognize him as their landlord. That's from this, that's how the Kabaka came to get the name Sabataka. He's the owner of the land in Uganda. So you, all of Uganda, are just tenants on his land. Okay, that means they are lawful occupants. Okay, that's why when you go to Chibuli, people in Chibuli, the big man said, okay, they don't pay Busuru. He excluded them. Okay, Kapunguru. They don't pay because that is Kabaka's land. Kamba nze Sabataka. So I have the right to make you pay the Busuru or not. So excluded people in Chibuli. That's why Chibuli was saying that na futi tano kumukaga. That's it. Naga ntundao. Nenga mujia mtoile. Yes. Okay, that's why Chibuli is the slum, because of that. Okay, so because of this law, so the big man gave them that freedom, so they are lawful, they know him. Then another one, Toro landlord and Ankole landlord, is the same thing. They have to recognize the kings, because they believe that all land should be belong to the kingdom. We are subjects of it. So Kabaka yanyo tugabira ko byalina. Okay, because of these laws. So you are a lawful. Why? The registered proprietor of the land knows you. Okay, then after the signing of the 19th of Uganda Agreement, Semei Kakungulu had to extend this to other regions. Okay, then B, a person who entered land with the consent of the registered owner and includes a purchaser. Okay, so when you look at B, okay, someone who entered land with consent. I used an example. Okay, I repeat this example, but for academic purposes, not a politician. Okay, I am not against any government. I subscribe to the current government. Okay, when it comes to when you look at the NRA war, when it came into existence, okay, the Bush war in Ruel, because of the issues in Ruel, people in Ruel left Ruel and they came to other places. But where they came, they didn't have land that side. Okay, so because of the system in Uganda that we welcome each and every person, these people were allowed to enter into land in other places, but with the consent of the registered, so they became lawful. It's like, once you allow me to spend a night, okay, I am there on your mercy. If you say Islam again, okay, you know my existence. You get it? So as a result of that, What happened is when these guys left, let's go to Gomba. Those two went in Gomba because some of them never went back. And then the person who allowed them on this land eventually died. And these guys were left in possession. You get it? But remember, the person who died also had children. You get it? They have an equitable interest. Why? They were allowed to go, yakkiriza taata okubeera ku ttaka eryo tosobola kugamba nti you've had such stories because of this. Okay, so that's the first category of a lawful. Then here it also has and includes a purchaser. Okay, waliwo abanga situnda ttaka lyange tunda ku nguudo. You ever heard of them? Okay, situndha ttaka era obuna ttaka kibanja. When you say tunda ttaka means you're selling the title, the legal interest. Okay, so what people do, they sell the equitable interest. So you buy the kibanja interest. You get it? You've purchased, but not the legal interest. We have Baganda here. Okay? Yes. These things are acceptable here in Uganda. I can sell each one when I have the title. That's why here in Uganda, because of that thing in Uganda, we have a law which is known as optional purchase. You have squatters. Actually, in English, they are called squatters. Okay? The Vibanja holders. You can purchase the Chibanja interest when the person you purchased on has the title. Okay? If not, you can be a purchaser, but when you've paid half purchase price. Yes, sir. Okay, what it means, okay, that when you have a legal interest, okay, you have a land title, you can sell to someone without giving them the title. So what you sell to them in Uganda is what we call a kibanja. Okay, you own, but you don't have you never get a title. Okay. Now, okay, the essence of the why it's called kibanja. Okay, it came from part payment. Okay, that's why I said I'm giving you this land, but you'll pay in installments. Okay, in Uganda they were calling it kibanja mpola. Okay, malayo nja kuwa ekyapa. That's how it came to be called kibanja. That's why they say wegule. You get it? That's an option of purchase. That after paying at wegula, then you start paying for the title as well. Okay? Because people wanted to own land, but they never had money. So the option available was to go for part payment. So you could come a taka has around 100 acres. So you could want 10 acres. Now, okay, I'm going to give you 10 acres, but you're going to pay in installments. What called part payment. So that's how the name turned into kibanja. You are there, but you purchased, but on part payment. So now we have it also in our common system. Okay, what we call part payment. So now we are together now. Yes, because you're there, you also have an interest now. You recognize because you paid him money. Okay, so we're together now. Then after that, okay, we also have what we call part payments. Leave alone this the purchase I've been explaining. We have part payment where you are buying the legal interest, but the purchase price is 200 million shillings. But cash, you have 100 million. So as a result of that, we can't give you registration until you pay full purchase price. So as a result of that, you become an equitable owner. I remain with the legal interest until you pay full purchase price. Okay. Then when you come back to section 29, it has another category. Okay. With the exception of the lawful occupants. Okay. We have another category known as a bona fide occupant. Okay. A bona fide. So how many have we seen so far? Okay. So bona fide occupant. I'm still relying on the same example. Okay. Remember, I've said that when the NRA Bush War came into existence, people left it away. Okay. And they became lawful occupants somewhere. But these guys were also registered proprietors on a certain piece of land in the way. Okay. But they left that land well knowing that kulikamba tyakakampinzeeko olw'ensonga y'olutalo nga bakimanyi. Okay, nti gye bali naye baddayo, singa baddayo tebandifunye ettaka lyabwe, then how was that cured? It says bona fide occupant means a person who before the coming into force of the constitution. Okay, I'm using this example for academic purposes. The NRA Bush War came in what year? Yes, it was around 86, 81, 82. You count from 81. From 81 up to 1995. How many years are those? You count. You can count and calculate. Okay. You count. Okay. I'm using this for academic purposes. Okay. And for purposes of understanding. Okay. So how many years are those? 14 years. When you read this section, it says a bona fide occupant means a person who before the coming into force of the constitution, okay, had occupied and utilized or developed any land unchallenged by the registered owner or his or her registered agent for 12 years or more. For 12 years or these guys who left the will, they had registered interests, not so? They knew that this land has been, did they go back? So these people stayed on that land for how many years? From 1981 up to when the constitution was made. 14, 12 or. So that means these guys who left the will, they ceased to have ownership. You see the calculations, okay? They ceased to have ownership. Why? They never went back to challenge. Okay? Now you go to the well, you will tell me what kind of people are there. Okay? What kind of people are there? Go to Moma. Huh? I'm using that example for academic purposes. Okay? Now you get it. This person is on land unchallenged. Is this person registered?
No.
Now you remember how I told you that adverse. Okay. Now this person is that's what called adverse possession. But once you've stayed on that land for 12 years, you can get a certificate of title under what we call title by possession. You will tell me. Okay, then we have that first category. Okay, I'm not intending to offend anyone, but I'm just using it for academic purposes. Okay, then another one, they say that then listen to B. I'm also going to use this example for academic purposes. Okay, had been settled on the land by the government or an agent of government, which may include the local authority. Stop there. Okay. Now we have people who left the will because to get power, they had to first take over the city. Not so? So those people who left Luwero, they came to conquer the city. They never got in land in Luwero. Not so. They left Luwero. So where did they get? Go to Kololo. You look at all those old-fashioned houses. You tell me the owners. Who placed? Did they buy? Okay, did they buy? They were placed on that land by the government. If you come out to complain, the under subsection 2, the government should compensate you. But after settling those people there, okay? One of the houses, I watched a certain story of the wife of the late Maria Moon. She stays in Lower Nakuru, that's slum, Karen. That's where she is. Okay, she has a single room, but she had a mansion in Kololo. But after the war, she came to claim the same. You know how we came to have Acholi quarters? Acholi quarters in Nakuru. Okay, why? People who used to stay in those houses, most of them were from Langese, because the government that was in was Langese. So these guys had placed their people in good places. Eh? So after their government was overturned, they had to get somewhere to stay. That explains why you have Acholi quarters. And when you go there, you stay kind of over there. Not so. They tell you, my father is a former military officer, where. Now you get the story. Then the people who are in those houses where they used to stay, okay? Who are they? I don't know. Now you get it, okay? So the government placed these people on that land. They are, whether they have the title or they don't have, okay? They are what we call, they have unequitable. So if they want, let them get titles. Once you get the title, now you turn until you go, okay? Now, you see all those, do we register? Okay, then you have another equitable interest known as beneficiaries. Okay, beneficiaries. We are all beneficiaries from the estates of our parents. But can you own it now? Okay, even if your parent passes on, trust me, share. You can't take it until they give you your portion. But you have a right to claim. You get it? You have just an equitable. Show us that you got. Once they give you, you mutate off local plots and get a title. That title, no one will ever dispute that. But before, obo yogezachi bigambo. That's an equitable interest. It's impossible between you and the other party. Oliwaddengo kayana stata yalekiri ttaka. Nebagamba gundi agabire. You get it? It's just impossible. You have any legal claim? That's how equity will come into place. Okay. Remember, once you get letters of administration, you register yourself on the title. But administrator, legal owner, legal interest. You get it? Now, you the beneficiary, you have an equitable interest. Administrator, whatever wakisanyo kumutima, asobola obbayisaawo. Okay. For example, the work the IA did yesterday. Okay. Now you get it. Let's go on. Yes.
Before you share here, when you are like 5 beneficiaries, how do I find my right that is protected me individually?
That's what now the next step is known as protection of interests. So we shall see how you protect the interest in land. Okay. Yes, guys. Yes. Yes. Okay. Yes. That's how it's now a restriction to the transaction of transfer. You get it? So it's just a restriction. Why? The law is protecting their interest. That's the way of protecting interest in land. Okay. Then another equitable interest is under section 39 of the Land Act. Okay. It's what we call 39 of the Land Act, the amendment. Okay. Once you, what are the importances of marriage? Legal effects of marriage. You get what we call. So those you get it. Chogulanga kutaka. But because you are married to that gentleman, yeah, atundenga tagambya akunyenya lwaki yakujjayo ewaabwe. Okay, both 38 has an equitable interest known as security of occupancy under 38. Okay, you get it?
Landholders beneficiary, that is where we call it ownership.
That's different. That's different. How to gain again? Just the 39 of the Land Act has an equitable interest known as security of occupancy. By virtue of marriage, you get an interest in my land. It is enough. So you are at liberty to go the way you want by virtue of marriage. Okay. Then another one we have family and interest in family land under section 38. Okay. Is it 39? Okay. We have what we call security of occupancy. Basically the spouses, not so. Every spouse. Which section is that? 38. Then 39. What's in 39? Okay. Those are legal restrictions. But under that, we have family land as well. It is also an equitable interest. It's also under 38 as well. Family land. Okay. Kasitoba ng'ova mu kika kya Haji Mikidadi oba yakuzaala oba si yakuzaala ettaka lyammwe. Kasitoba ng'omufaanana nakyo kikulu. Okay. Now you get it. Okay. Then another equitable interest. See what they are? Because once you enter that fund, they can ask you. Their range is always 5 to 7, but they can ask you 10. They see how you can stretch. Okay. So we together. So now we've looked at these interests. Okay.
Answer.
That's an interest. So right. It depends the type of license. That's why that topic was separated. Okay? Because a license is temporary. You get it? It's temporary. But all these are permanent. That's why it's not regarded as an interest. It's a right. Okay? But there are mortgages. Okay? You can also include equitable mortgage. It's possible between you. Okay? So now we've seen the rights. How do you protect your rights in land? That takes us to another topic known as protection of rights in land. How do you protect it? Okay? We have two ways of protecting an interest in land. Yes? Rights gonna too high.
I've seen rights.
Okay? Well, I've seen the interests. Okay? Yes. Okay? Yes? You become meaning of lawful occupant. You fall under lawful occupant because you've occupied by consent. Okay? So now we go on. So how do you protect the interests we've seen above? We said you have two ways of protecting the interests. One is by lodging. So let's go to caveats. Okay? Caveats. So you ask yourself, okay? When you read the case of Katharikawe versus Katirem, court held that the best way to protect an equitable interest is by lodging a caveat. So that takes us to types of caveats. Okay? We have a caveat under section 20 of the RTA. Okay? Under what circumstances do we use that? Okay? It is used when you are forbidding land to be brought under the operation of the RTA. Okay? It forbids bringing land under the operation of the RTA. So how can they ask that question? They can tell you that council, assume you are a family lawyer to the family of Haj Nikidat, who owns, okay, land measuring approximately 1 hectare in Tambala. His son, you've learned that his son has applied to acquire a freehold certificate of title from the district land board. Haj is before you. He says he has never given consent to this son. He's just a prodigal son who tries to collect what he didn't work for. Council, proceed and advise him. This is customary land. Remember, customary land can be owned according to clans, families, and communities. That's a family, okay? Zacharias Kisingiri. It's a family, it owns the entire Bombo, okay? They own the entire village in Ruwero down there. Because it's a, okay, you get customer, okay? Like that, customer. So now, when it comes to this, okay? When it comes to this boy is trying to transfer land from customary to free. Remember, under freehold, this boy is going to come out when he's the registered proprietor. And once he appears on the title like this, section 59 will apply. The certificate of title is conclusive. Because the title will show that is the first registered proprietor. Then you start battling for fraud. Okay? But remember, the guy has proof which you don't have. So how are you going to revert that position? So once you get to know that this boy was not given consent, ask yourself, has this land crossed under the RTA? Remember, the RTA only deals with registered. So to avoid this land, the freehold certificate to come into place, caveat the process under section 20 of the RTA. You don't caveat the title because the title is not yet out. Okay? So you caveat the process. It's customer. Because once it crosses, okay? That's why the fraud is tasked. Because they know. No one knows the law like a fraudist, I'm telling you. You're joking. They know. That's why they want the title. Okay? That's why they say, simple as that. And now we can answer backwards. Okay? We have Prado TX. Okay. Now you do Katono. Nani nitaka nawe nafuata mnomuulira motoka yevugamu yoke ekiro yekubemu So you get it. So let's read this section because you can enter and chorus they ask you to give them the different types of caveats. One in a woman age, they are 39. No beneficiary caveat, no comma, no words and Nenga zono zirina. Zirimeka. Okay, they are around 5. Okay, so ask yourself, how many do you know? So take your time. Okay, so section 20. Yes. Okay, section 20 says of the RTS, that is interested. Okay, it says any person claiming any estate or interest. Now you get it. You claim the estate, that is the registered or interest. You get it. Okay, you have an equitable interest. So that means the person with customary has that interest. So how will this person protect that? Okay, it says that in land described in any notice, okay, in any notice issued by the registrar under this act, nay, before registration of the certificate. You get it? That's what I told you. Before. So when they ask you, first note, break the question, is the title out or not? Or but let's do it for the customary. Or what was on a common customary? The title was a full. Customary. Or section 20. Before the title is registered. Once the title is out, you change, you go to 139. You get the difference now. So the first caveat is a caveat forbidding land to be brought under the operation of the RTA. That is the caveat under section 20. Then we have another caveat that you people know very well. Okay, that is the caveat under 139, what is commonly known as a beneficiary caveat. Okay, which is commonly known as a beneficiary caveat. So we need to read that. Okay, then the third caveat, who knows which section provides for the powers of a registrar? Yes? Look at 170 of which law? So let's go to 170. We have a caveat under that section. Okay? (139) has a beneficiary caveat. Okay? Then 170. Okay? So we have a caveat under section 170, paragraph A. Okay, it's known a caveat on behalf of government. So what you do under that section, Ojamu caveat says B, under 170 paragraph A. Get two caveats. Let's read it. It says, a registrar may exercise and shall perform the following powers and duties to lodge a caveat on behalf of the government. That is one. Okay? That is one. Then, or on behalf of any person who is under a disability of infancy. Abana abato. Okay, registrar asobola okukeera ku makya namugamba Haji afudde nenga mukwano gwa Haji. Haji alese ebyala myaka 3, 2, 4. Naye nga abaliwo baluvu bazibu. So now by the time these kids grow, this land will not be there. So the registrar has the powers to lodge, okay, a caveat under that provision. Okay. Then another one, because that disability, even a person of unsound mind. So okay, you can break everything. Okay. 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 You can go on breaking. Okay. Number one, a caveat on behalf of government, a caveat on behalf of minors, a caveat on okay. Hey. They are looking at your creativity. Persuasiveness. Can you persuade the judge in court? Mugambe counsel. Okay? Those are types of caveats. A minor is different from a person suffering from a mental illness. They are different people. So the caveats are different. The grounds of lodging a caveat of a minor, are they the same grounds? They are different. So aren't they different? Okay? Persuasiveness. You need to pass. Okay? So then another one, they're saying that, okay? Or absence. Okay? Absence from Uganda. Absence from Uganda. When someone is out of the country, the registrar has the powers to lodge a caveat on his or her behalf. Yes? You're outside Uganda. You are outside Uganda. Okay? You get it? Because it is the same thing. Kati gozimenye mkati awo gojewo caveats meka. Okay. Okay. Hey. Then which other caveat do we have? We have another caveat. I have section. Okay. So let's go to section 86 of the same act. Okay. Because we don't caveat land which is not destined. Okay. Mark that. Okay. Okay. Now you get the challenge. When you look at 86, okay, Gobojisoma, caveat forbidding grant of application. Oba wakaita kao katon, wosanga what we call certificate by possession. It's under which section? Okay, it's under which section? By possession. Title by possession. Yes? Yeah, that's what I'm going to explain. Okay? We go on. It says, listen. Okay, caveat under section 86, it says, a person claiming any estate or interest in land in respect of which any such application is made, may, before the granting of the application, lodge a caveat with the registrar forbidding granting of the application. The caveat shall in all other respects be in the same and the same subject to the same provisions and have the same effect. What does this mean? Any application. So what applications can you make? Okay, what we call a vesting order. Okay, so what it means, you have applied for you to get what we call a title by possession, what you call a vesting order. Because you have vesting orders be, okay, 2 vesting orders. So where you make an application for land to be vested in you, okay, on the grounds that you've been occupying land for 12 years. So now how can they ask that question? Remember, for that land to be given to you, the following conditions should be there. 1, you've occupied it for 12 years before they come into force of the Constitution. Then 2, uninterruptedly by the registered proprietor or his or her agent. Then 3, you are in physical possession of that land. Then 4, you've been occupying and utilizing the entire land you've applied for. You applied for 400 acres, but you're using 20 acres. Okay, so once I get to land on your application and I find that those grounds, okay, you don't fulfill them, I lodge a caveat so that the application is not granted. You get it now? Okay, you've applied that. That's what's called application. Okay, we've said under this, okay, the application you've used, an application to be granted a certificate by possession. Okay, you've been advancing occupying this land for 12 years uninterruptedly. You're thinking, okay, so what happens once you apply? Court, the registrar will come, they will go, they do boundary opening, everything. Then after, they'll issue what we call a notice of issuance of the certificate. You advertise it in the newspaper, you put everywhere as the law recommends. So once I see that advert like this, okay, so now because I know I have ever sent my son, okay, the bottom mutabanyi wange naga kaya linetaka lilyo naye ngali siyajaja just an interruption kama neka bakali katika Saul kama naise nyama ono mwami tumulabangako, you get it, kyajja nanga mitaka yajjajawe naye teyadda, you get it. Is that an interruption? So that means I'll lodge a caveat basing on that I interrupted you. That one is my agent. Okay, if not, you said that after the boundary opening, the land is 200 acres, but you've been occupying and utilizing only 20, but you've made an application for the 200 acres. Isn't that proud? So I lodge a caveat that you don't qualify. You have ill intentions. You get it? So that's the caveat under section. So now you are supposed to go money maker. Yeah, huh? You have any other type? Yes? In it? Yes? Okay. We have another caveat under section 100. 160.
Rashid, 170.
170.
Registrar's caveat.
You had dropped out, eh?
Waliendera 89.
89.
Application caveat.
Section 100 what?
Section 89.
Let's look at 160.
61.
161. Okay. It says person objecting to the application being granted may lodge a caveat. Okay. So this caveat under here, we have what we call ratification of the register or ratification of the title. Where the title has errors, okay, you make an application to the registrar to ratify those errors. Now you know that we have some guys who put errors in your titles intentionally. Okay, intentional. Okay, whether you like it or not, I know. Okay, for example, my mother bought land. Okay, there were two plots. Okay. One was at the main road, another one was just behind that plot. So the agreement she had at home was buying the land on the main road, not behind that plot. Okay? So, because by those days, when I was young, I couldn't enter into such transaction. I never did again. Okay? So, when I joined second year, she sent me to pick her title. But you know what this surveyor did? He made the title the opposite. Okay, the agreement we have shows that we bought the plot just at the end when we just started the road like this, but he gave us behind that plot. So the title we have reads another plot, and the agreement we have is for another plot. But the challenge is section 59. So I told her, you can't challenge. Why? An agreement can't supersede the title. Okay? But this was an error which was done by the surveyor intentionally. Why? This guy had a potential client who wanted to buy that plot. So because he knew our mother wasn't around and we were minors, we couldn't call her. So that's how we came to put that error. So if we apply, that's why I told her, don't apply to effect changes on your title. If we applied, this person could challenge, this person that plot could caveat that application. Why? We've never been in possession. You get it? The title is conclusive evidence. So how could we get now? You get it? We would want to challenge that position, but we can't challenge the position. We've never been in possession of that plot we are talking about. So how can you challenge? How can you tell the registrar to make amendments? On what basis? So once you make that application, that person will proceed under section 161 and he caveat it. Okay? It says, a person claiming any estate or interest in land in respect of which such an application is made herein before provided may, before granting of the application, lodge a caveat with the registrar forbidding the granting of the application, and every such caveat shall in all other respects be in the same form. Okay? Because when you look at the short title of the part you are reading of part 10, says ratification on titles. So that means this is a caveat forbidding ratification. Okay? You get it? Now you see, they are different. You just get the heading, kindly by force. Okay, no jewelry. Okay, so this is a caveat forbidding ratification of the title. Where the title has an error or you want to make any changes, the person to stop that process loads the caveat known as a caveat forbidding ratification of the title. The other one is known as a caveat forbidding land to be brought under the RTA. The other one is known as a caveat lodged by the registrar. The other one is known as a beneficiary caveat. The other is known as a caveat forbidding grant of a title by possession. You see, okay? So now, then
Rashid,
another title is not under this. Yes, Council?
there's another caveat, either in 86 or 89. Let someone check there. I don't have the act near me.
Okay, I'm there. Yes, Council, it's under 86. That's what we call a caveat forbidding grant of a title by possession. We dealt with it. It's under section 86. We dealt with it.
Wherever in Muganda. And in all circumstances, aren't all those other caveats brought under the same procedure as that of 139?
That's why they say it shall take the
apart,
same form. It shall take the same, because for 139, the law has provided its content. So that means you have, when you look at, they say with the necessary modifications. So what that means, it takes the same format as that of 139, but with the necessary modifications. So it's the same procedure, Council. So now you ask yourself, what do you okay? So now, with the exception of lodging a caveat, which other way can you protect your interest? Okay? It is by taking possession. Okay? It is by taking possession. Okay? The second way of protecting your interest is by taking possession. Okay? By taking possession. That's why these guys know. Okay? I know some of them here. Okay? Yes? Possession is in different forms. We have actual possession and physical and actual possession. But we are dealing with actual possession. Ask those guys, actually constructive possession. We have people, people are funny. You've seen that. Okay? Constructive guy you are in. Yes. Okay? Then you never manual. Okay? Yeah. You ask people who have ever worked from the window, they know. From the window. This guy is by land, nazimbako katoi. Kamusiko, kunakazimba wakati mkoroti, na agenda. Na maleni yake eji. Nga likule valley. Nga buitoi wegwa achimanya nakoona achizimba. Okay? So that's what we call possession. So when you buy land, before you do anything else, take possession. Now let me tell you, there is some land on Ontario Road. Some rich guys, popular, found this land back at the CDDA. Naja na iwa matini. Newa ndiko zimbe ngalinda nyini lyave yali akatigula naye atamani nyini tata. Nazimba kechikomera. Kati we yasimba badanyi taka ne bajja kati ne bagala omusuubinga ali in possession. Wallahi tewako ngali yagwe ne title wajirina na ajiwinga possession na agamba we didn't consent kamba gule. Okay? Nga tebakyasobola kuzzaayo construction gyakoze tebasobola kugimenya. Okay. Kati kaso nabagamba kati naayita ku kasana bakkiriza consent. We consent banguzeewo. Janoonya oggulawo ne bamugula. N'ayiwa material n'azimbawo kati ne bajja ne bamusuulinga. Okay? For trespass. Now, okay, so bulijjo omwe benoonya bananyini ttaka. Okay? Now, let's enter into a consent. Ne bakola consent n'abasasula. Ne bakola ate bakola self-agreement court order ya kimala. Okay? So when you have land, don't really give back up. Yeah? Look here, already are in possession. Yali amalinze bamenye agende mu criminal ateko malicious damage to property. Then ategwa criminal gudduka. Nga tebalina option okuddako okukkiriza abagule. So once you have land, either lodge the caveats or sirike and take possession. Because once you don't take possession, at first we shall look for that land, whether you like it or not. Okay? So now, you've known, you see how we are moving? So now you've known how to protect your interest. Yes? You have taken possession. It is also fence. You've also taken possession. Okay, it's a form of construction. Look at, remember where I started from. Okay, what is land? Once you dig and insert the poles, or can you put concrete, it forms part of that. You get it? The degree of fixation automatically answers you that you are in possession of that land. Okay, so it be okay. Once you plant the tree and it enters that land, when you are trying to uproot it, it will go to damage that land automatically. Okay, that's why we have to start with what amounts to land. So now you've seen how you protect your interest. Okay, so now ask yourself, this interest, okay, I own it under what tenure. So that takes us to what we call tenure systems. Okay, tenure systems. Okay, tenure systems. So when you are dealing with tenure systems, you start with Article 26. Article 26, which says that every person has a right to own, okay, to own property individually or in association with. You underline the word individual or in association. So that means the tenures we are seeing here, you can own it as a single person or you can own it two or more. That explains what we call co-ownership and joint. Okay, now Council was asking about how do we get to joint tenants and co-ownership. Now we are there. Okay, so now, okay, so because Article 26 as you an individual or in association with others. So that means me, I can own land under any tenure, or both of them can own land under any tenure. Okay, then when you go to Article 237 clause 1, it says land belongs to the citizens of. So what does that mean? No any other entity has a right to own land in Uganda. Okay, land belongs to the citizens. The government China attack. That's the general rule. Okay, Article 237. That's the general rule. Okay, but each general has exceptions. When you get to the exceptions, we shall say to that position. Okay, so but that's the general rule. Okay, then Article 237 clause 3 says that land shall be owned in the following tenures. So the first tenure is, the most paramount mile, mile tenure. Okay, but now the Constitution doesn't define for you these tenures, not so. But when you go to the Land Act, Section 3, it defines each and every tenure. It gives the different incidences. How you can say on a mile, on a freehold, on a cheap customer. Okay, so when you are looking at these tenures, mile, when you read the Land Act Section 3, it says that mile tenure is a system of tenure which has its roots in the 1900 Uganda Agreement. Okay, Uganda. Why is it called Uganda Agreement, not Uganda? In which year? Look at the year when the Land Act was made. Okay. Commencement date is 2nd July 1998. You know why? Because the reason why this act uses Uganda Agreement, by 1988, Uganda Agreement had spread to all kingdoms. You get it? They used the same agreement, but only change of language. Okay? It's the same as the Ankole, same as Toro, and it's extended everywhere in. So, but it's the root of mile emanated from. So that's why it's currently referred to as the Uganda Agreement, but not Buganda. Once you say Uganda, you are restricting the original one. Okay, me have ever went to that home where that agreement was signed. Okay, it's there. The original version of the Uganda Agreement. It's here in Rubaga. Wait. Eh? But then I work out. Yes. Yes. The agreement is there in Mengo. In Mengo is there. Me, I went to the home of Stanis Mugwanya. Those kids of his happened to be my good friends. So I went there. Even the table where they sat when they are signing that agreement is there in the sitting room. Wait, up to now. Okay? Up to now, it is there. Okay? It's there. Okay? But the family refused that place to be used for tourist attraction. The family refused. They wanted to gazette it, eh? But once they gazette it, it's going to government. So the family refused. Okay? Even his house is there. They just paint. Even the paint is prescribed in the family meeting they use. Okay? It's there. Everything the way he used to do it. It is there. Okay? So me, I went there. There is a caretaker. Okay, whom I went with, they showed me these things. That agreement is there. But it was good and bad. That's why some of us are suffering now. Because that was the starting point of the confusion in land. If it wasn't signed, those families wouldn't have gotten that land. Okay? Yes. Because that family, that agreement divided land into how many? Iri. All those lands, they are measured in miles. Okay? So the Baganda said, mile. Now you get it. From mile, M-I-L-E. That's why it's called mile tenua. But the actual meaning, because they were measuring land in square miles. Katanaka square. Na Baganda kabakola bubishi. Batugambye biri mu mayiro. Okay? Ate Baganda bali bapimana bigere nga batambula bwebati. You get it? That's why it's called. So bo kyabatawaanya ne bakituuma mayiro. Ne bagamba kabaka bamuwadde mayiro 9 mu ndagaano zize. You get it? Kati bano abayambako kabaka okusayininga buli omu ne bamuwaayo mayiro. Okay? So the entire Rubaga was belonging to the family of Stanis Mugwanya. That's why after Mugwanya's death, the successor was called Kabusu. So Kabusu got an accident around that roundabout where there is Total. So after his death, that place was named Kabusu. Okay? Then after Kabusu, they had another one, another name. Upon his death, so they kept on. That's why the entire Rubaga, it has names of people from that family. So that land was given to that family. And another land is in Manyangwa here, Gayasa Road. There is a school up. It's called Manyangwa Primary something Mugwanya. That land is big. It was taking almost half of Gayaza. but the kids sold that land. Last time I went there with this guy, my colleague, because waliwo ekibumbe kya mugwanyi wekiyimiridde we baasigaza n'essomero around 1 acre abalina the entire village of Gayaza. Abaana batuuze babe, even Kamocha here. Okay, so they gave them different land, but after that land was divided according to miles. That's why when you read section 3, mile can be owned by a family, an individual. Okay, you get it? So that family will have that title. Okay, so that's why Milo has its origin in Uganda. So bonogende walala tewali Milo. Milo land is only here in Uganda. But if you read further, even in Ankole, Milo was there, but it wasn't popular. That's why people didn't consider it. But the reason why it was made unpopular, the kingdom was abolished. Okay, but they were copying exactly what was in Uganda. So, but after abolishing the kingdom, it ended there. Even in Toro, Milo was there, but it was also abolished because the kingdom, remember there is a time where all kingdoms were abolished. So only the strong kingdom came back with all its way of doing things. That was Uganda. So those guys failed to revive Mile, never like that. But they have freehold now only and customer. Yes, sir. You ask yourself why? Why? I don't know the truthfulness of this. Okay? The truthfulness of this. But even one of the houses of the big man, the presidential houses, Erikumayo, Chapa Chidimo. That's why the big man told them, after the president giving that over, what about the empire get up mind? He knows the danger of dealing with mind. Okay? Remember, they're still demanding them. Maida Kenda. Okay? Kampala inagenda mu district zonna z'olabisa Kampala. Kati bakawe basigazeewo. Yes, Council.
Yes, I have a question.
Yes.
When you say that in Uganda here,
yes,
the titles are under Milo. Yeah.
Yeah.
I want to get a clear view on the titles that we see here in Uganda that are freehold, that are under freehold, and they are in Buganda, like say the areas of Mityana Road.
Yeah, no, Council, it's like this, okay? In Buganda, all tenures are there, okay? But in other areas, we have freehold, mile, and customary. Mile is not there. Here in Uganda, we have mile, customary, leasehold, and freehold. Zona to Zina. But mile doesn't exist in other places. The other tenures Jay-Z with the exception of mile. Okay, but it was there, but because of that, okay, are we together? Okay. So now we've understood what is mine. Okay, then let's go for customer. The reason why I want us to deal with freehold and customer at the same time, I want us to understand the process of converting from customer to freehold at the same time. Okay, are we together? So let's go to freehold. Okay, so when you look at freehold, they say it has its origin in the constitution. Okay, it has its origin in the constitution. Taylor way back. Freehold. Okay, you get it. Freehold has its origin in the constitution. You trace where it comes from. Okay, you get it. So because of the freehold tenure, the law has institutions that issue freehold. Have you realized that most of the titles of freehold, okay, emanate from leaseholds that are granted by Uganda Land Commission and District Land Board? You get it? You can't have a freehold from mine. Okay, you cannot. Okay, so what does that mean? A freehold certificate emanates from the constitution. It has no background whatsoever. Naffe twagirabirawo nga weeri oba ani yatula n'agiyiiya. Okay, but when you read history, the word free, okay, the word free, sisi Meika Kungulu, okay, has land in Mbale. How did he get that land? Because he was given the duty to extend colonialism, okay, in Mbale. So by virtue of appreciating his work, he was given free land in Mbale. Okay, by the colonial government by then, okay, he was given free land in Mbale. Okay, so after that, because the system now he got titles, but those titles were referred to as freehold. But remember, these guys can't tell you to do something without conditions. Okay, you can't. So that's why freehold, when you read section 3, it has conditions. You can't get it just like that. So the condition of Kakungulu getting that land was to extend colonial rule to Mbale. That was, but eventually when the law came on changing, it is granted on certain conditions. That's why you can say freehold certificate of title. When you go to the conditional page, it has residential on it, commercial, agriculture. But that's how it came up, because these guys who are helping the colonial government, they are given things free of charge. But to get ownership, they had to twist the law. Because even if it's me, okay, I'm not saying that I want to become the president, yeah? But even if it's me and I have in my government the people who happen to be in power, why can't I protect you? Market camp, I have to protect you. So that means I have to make laws that favor you. So that's how people came to get the freehold. But remember this land, you get it? Okay? Who owns that land? Customary. That's why you, after being given this land freely, you have to convert it from customary to freehold. You get the title. That's why you carry on. Now you get it. So that's how freehold came into place. So when you read here, a freehold certificate of title has its origin from the Constitution, and it is given subject to conditions. Freehold certificate condition. Okay? Are we together? But all you need, so now, after that, because you've explained that this land was given to these people, but when it has already people who own it customary, then that takes out what's called customary tenure. Okay? Customary tenure. Again, when you come back to section 3, okay, of the Land Act, it defines customary tenure. That one we shall read it for purposes of understanding, because it has different ways how they are treated. Okay, when you read section 3, subsection 1, it says customary tenure is a form of tenure applicable to specific area of land and specific description or class of persons. It is applicable to specific areas. The way we own land customary in Uganda, you can't take it in Jinja. Here we say Sabataka. Okay? Abasoga, they know how they deal with their kingdom. Okay? Chabazinga kwa community there. Nothing takes place. Okay? Okay? So it is, so you can't enforce the customs from Uganda to, when you go to Kalamajoms, they believe in communal ownership. So you can't bring communal in Uganda. It operates. Same people from the West. People from the West are just changing, but they also believe in communal ownership. You just wake up, you say, my cows have to graze from there. No one will chase you. You graze your cattle from there. Okay? That's what they call true definition of Bahima. Okay? Yes. Okay. And Bachues. Okay? They never disappeared. They are there. Okay? They are there. So for them, they believed in communal. So you can't bring one of Uganda. Yeah. And you get it? Because for us in Uganda, we don't believe in communal system. What you have is yours. Okay? This land belongs to the family of so and so. Yeah, way. But when you go to the West, you can let your cows freely go and graze from someone's land. They have no problem. But come here. Okay? You get it? So that form of customary applies to specific places. You can't enforce the customs of here to. That's the first interpretation. Then they're saying that there is one I'm interested in. Yeah? The last one, which is G. Okay. F says providing for communal ownership and land use. That one we know it. Then we have E. It says that applying local customary regulation and management to individual and household ownership, use and occupation of land and transactions. You get it? For example, we have what we call applying local customary regulations in Uganda. So that means those are the customary regulations. Okay? But to go to the West, is that the way it is? No. Okay? Then further, they are saying that interested in now in the last one, it says that in which parcels of land may be recognized as subdivisions belonging to a person. Yeah. You get it? Okay, you hear that? You get it? That's one person. Then B, a family. You saw you hear those things in Uganda. Then O, a traditional institution. You get it? Okay? I don't know. Okay? Because they have their own customs. But I'm using customs that you understand here in Uganda. But currently you have land where Chambugu is. They're saying that that land belongs to one person who? Namasole, mother of the queen. But Chambugu has a title. Over how? We don't know. Okay? Here, that farm, that title is in the names of Kabaka Ronald Muwenda Mutebi. Okay? His land, but Ham has a title. How? We don't know. You get it? Those differences. So in Uganda, customary here in Uganda, we believe an individual. This is the meaning. Okay? Then clans or institutions. Okay? Mbuga ya Buganda. Buganda is an institution. Mbuga ya Buganda. Katigogenda. Okay? Encroach on that land. You'll see problems. Okay? Me, there is a day I went in a transaction, but I was selling my land. Me, I didn't know. So, man, a deal came. This land has a very beautiful rock, which has water coming from the top. It's this ends of Matuga. Okay? The place is called Kungu. So, for us to believe in customary, that's land for people from Mbeo clan. So, me, I come from the Mbeo clan. So, I get a client who wants, yeah, me, I didn't know that is our ancestral home. So I go to the Chinese, they said, oh, this is money. This is money. This rock is very beautiful. But you know, these things are fun. Okay? I don't know what happened to the client. The client had even prepared the money. I started making plans. Yeah. Because the transaction was around 5 billion. Yeah, the number one. But I don't know what happened. Okay? So, now after getting, I hear people saying, so I had heard of this story at home, yeah? But I wasn't aware. I kept quiet. So unfortunately, we go in the family meeting. We found a quarrel at home when the traditional head of the clan sold that land. And to make matters worse, I had ever seen the titles that was in my possession. But me, I didn't know. I was the one issuing out titles. I said, you are when you get it, I kept quiet. Why? Because that land is from Pewo clan, so it is held customary. So that means in Uganda, that land has no specific owner. Where the head of the clan dies, the successor becomes a registered proprietor, like that. Okay, customarily. So no one will say that if Takarian, then I call it and subdividing a so that's business. It's a land transaction. I did a transaction. Okay, not a tenure. Okay, so now we've seen customary and then freehold. But ask yourself, okay, can customary get a title or not? So what you should note, customary has no title. Have you ever seen it cancelled? Okay. Okay, so literally it has no, because a title should be under the RTA, but under the RTA we don't have that title. Okay, so that means for you to get a title on customary land, you have to convert it from customary to free. So that takes us to what we call conversion from customary to freehold. But we know that process not so. The simple process. One, okay, you make the application, okay, you get the forms, okay, yes, transfer from customary to freehold, okay. One, you make the application where?
To the land.
To the area land committee, okay. You make the application to the area land committee, okay. Then after that, okay, the area land committee will come for, sometimes they issue a notice first, okay, but this notice is calling all interested persons, okay, to come for a meeting on ground. So the area land committee comes to the ground to convene that meeting and do what we call boundary opening. The essence of the meeting is to ascertain whether you are occupying the exact acreage you applied for, whether there is any other person claiming interest in that land, okay, whether there is any dispute. That's the essence of the meeting. And then after, they'll do what we call boundary opening. After the boundary opening, they will do what we call a report, their findings. Okay, so that report, the area land committee serves a copy of the report to the district land board. Okay, after the district land board has received the report, okay, the report, they can confirm or they can vary. Okay, you get it? They can confirm or they can vary. Okay, so at that point, once they send and they receive the report, it depends what you want. Okay, it depends what you want. If you want to get what is claimed to be certificate of ownership, customer certificate of ownership, you stop there. Okay, once they read the report and they confirm, they send the report to who? the recorder. Okay? They will send the report to the recorder. Then the recorder will issue with
District Land Board sends a report
to the recorder. If they have confirmed that it's true, the district land board, after confirming the report, they forward the report to the recorder with the recommendation that issue a customary certificate of. Okay? So then after the recorder has issued the certificate, you get the certificate as a proof of ownership of that land, customary. Then you get what we call application for a freehold certificate. You attach the customary certificate to the application. Okay? You pay the necessary fees and lodge in your application to the district land board. Okay? But that application is for what? Freehold. So what does this mean? You first obtain a customary certificate, then you go for freehold. Okay?
Where does the recorder sit? Is it at
At
the
a committee, area land committee. Doesn't sit at the district. You a take a head prefect and a mess prefect in the same office. No. Okay. Okay. We've said after the area land committee has visited the land, they have made the report, they will forward the report to the district land board. The district land board will read the report. They either confirm that these are the true findings. Okay. After the findings, okay, they will, once they confirm that it's the true findings that they wanted, then what will happen? They will send back their report with the recommendations that issue a customary certificate to this person. Okay, so they send that report with its recommendation to the recorder. So once the recorder receives, then we shall go for issuance of a customary certificate. Now you have proof that you own the land customary, okay, without any dispute. Okay, so that means you are at liberty to obtain conclusive evidence, which is a certificate of title under the RTA, which is known as a freehold certificate. Okay. Now, if you don't have a customary certificate of title, you don't apply for freehold. Okay. Okay. Exactly. They are.
Then the Nandi District Board subscribes to the Nandi Register.
Okay. So you get it now. Yes, sir. Now, it was a certificate telling you. The report they make is the certificate. Yes, literally, they tell you. So that is a lease. That is a lease, not okay. That land you bought is not customary. You get it? You want a lease, but not a freehold. Okay. So members, I want us to finish this process. We are late for Juma. Okay. We are going for prayers, then we get back. We do the last part, and then we do questions. Okay. So now, after you have now proof of owning the land customarily, then you go to the district land board. You obtain forms of application, you pay the necessary fees, then you lodge your application to the registrar of titles. I get the difference. The customary certificate is issued by the recorder. Okay? Then a freehold certificate is issued by the registrar. That's the difference. Yes? Now you apply, the report will, once you apply, you don't, because you address your application to the registrar of titles, but the registrar of titles doesn't make an independent decision. So they forward your report to the district land board. Once the land board approves, then they will write to the registrar that Muwe. Okay? Yes, council. Yeah, they were phased out. Okay. Yes, answer. Okay. Okay. Yes. That's why I say once they approve the report, it is with recommendations. These recommendations are the conditions that issue him a certificate of title with. They give you the conditions as they deem fit. Those are what we say. It is restrictive. How? Residential, commercial, agriculture, like that. Because why? It depends on what we call the physical planning of the district. That's why on that committee we have a physical planner. Kino ekyalo kya residential, kino kya commercial, kino kya industrial. So once your application is under industrial, the restriction will be industrial use only. Once your application is under residential, the restriction will be residential. Okay? Developments come, okay? And things change. Namamve wasn't an industrial park, but because of the different changes, it became an industrial. So once you apply for land in Namamve, it is restricted for industrial only. But literally, but before that wasn't the position. So depending on how the world is changing. So after you've applied, then they will issue what we call a freehold certificate, but with conditions. Okay. So now we still ask, but during that process of applying, converting from customary to freehold, that's when you can lodge a caveat under section 20. But once the title has been issued, you lodge a caveat under section 139. Okay, so we are left with lease tenure, not so. So let's first go for prayers. We are going to have our next session. After the prayers, we are going to. We may not look at lease tenure. Why? It is a type of transaction. It's a full topic. You get it? So that means when we come back, we are going to look at what. So now we've seen what we own, everything. The tenures you have the proof. Okay. Now we shall look at what we call general restrictions to land transactions. Then we start a sale, and then we do our questions, and we call it a day because it's a public holiday. We need to be home. Yeah? And besides that, a discussion that exceeds 4 hours, it's not a discussion. Okay, I believe in understanding something small but perfect well. Okay, so let's go for prayers. Let's meet after. Assalamu alaikum wa rahmatullahi wa barakatuh. Thank you. Judith, kindly make me co-host. Council Vanessa, make me co-host. Okay, so we've looked at what is land, what do we own in land, how do we protect the different interests, okay, and how do we own these interests. Those are the different tenures. The only tenure that's not looked at is the lease or tenure. Reason, it is a topic that we need to look at independently. Okay, so that's the tenure we've left out, but we shall cover it. So now, after you've known what you own, okay, and you have conclusive evidence of ownership, okay, you can now transact, okay, you can now transact on that property that you own, which is land. So you ask yourself, what are the different forms of transactions that we have? Okay, so that means if you own your land, the interest through the tenure, you've protected it. So now you are at liberty to transact in that land. So that takes us to what we call the different categories of land transactions. Okay, the different categories of land by one. Then we zero down to one by one so that we are able to appreciate them vehemently. Okay, so now if you want to understand the different types of land transactions, go to section 39 of the Land Act. You open it. Okay, so we are looking at how you can transact in this land. You have owned it in whatever way you own it. Okay, you have owned it in whatever way you own it. Okay, so if you want to understand the different forms of land transactions, okay, just go to section 39 of the Land Act. Okay, you'll see what it mentions. Let's read it. Okay, it says, okay, so it says, no person shall sell. That is one transaction known as a sale transaction. Okay, 2, exchange. It's a form of transaction. Then 3, transfer is also a form of transaction. Then 4, pledge or mortgage. Remember when I told you to differentiate between a pledge and a mortgage? They are also transactions. So we have a transaction of pledge and a transaction of mortgage. Then another one is lease. Okay, so those are the first categories. Okay,
recording in progress.
5, there are 6. Okay, 5, there are 6 transactions as of here. Then after these that are mentioned here, add on other transactions. Then go to section 26. Article 26 of the Constitution says, no person shall be compulsorily deprived of underlying a transaction known as compulsory land acquisition. Okay. Then after that, we have another transaction which is known as condominium properties. Condominium properties. Okay. Condominium properties. Okay. Then we have another one known as access to roads. Sometimes it's referred to as easements. Okay, so now if you look at these transactions, they are the topics you've been covering. Okay, you had a topic on sale, you had lease, you had transfer, you had mortgages, you had compulsory land acquisition, you had condominium. Set up the same land. So literally, after the first week, workshop 1, we started looking at what we call land transactions. Okay, you get it? So your topics are in form of categories of transactions. So if for you read just, you may see that land is huge. Okay, so each topic you had is a form of transaction. So now we have to break those categories of transactions so that you understand those topics. Okay, so all of these are what we call land transactions. Okay, So this explains why the cost unit is known as land transactions. Okay, because you study forms of transactions in land. That is sale, mortgage, transfer, lease, condominium. Okay, so that explains why it's not called land law, because in land law we don't study transactions, we study the law. Okay, so now what we've been doing, we've been trying to understand what is land and everything. So now we want to transact on this land. So before you start transacting, there are things you should put into consideration. So that takes us to our topic known as legal restrictions to land transactions. That was my question number 2 in land. Okay, I was at panel E. Up, the administration. Okay, you're going to have 4 panels: A, B, C, and E. In all questions, panel A land, panel B corporate, like that. Okay. Luck will hit you. They're going to say corporate and commercial, panel A, panel B, panel C, panel D. So each panel will have judges. Okay, different people. Okay, so they will say Rashid is on panel A corporate, but again Rashid can be on panel C land. Okay, so luck will hit you differently, but chances are high if you are on panel A forever. Okay, no, you set panel A land, panel B corporate, panel B criminal. If you're on B, you can end up being on B throughout. Yes, but they will be having different people and on different days. Okay, so you just pray that luck hits you right. So now we are looking at legal restrictions. Legal restrictions, these are things that restrict you from entering into a transaction. So what you should know, the way of workshops were set, they have a problem. The problem is what we call a restriction. These transactions we've seen are categorized into 3 stages. We have before, during, and after. Okay, so when you are dealing with before, that means before entering into a transaction. So that means before you enter into this transaction, there will be a problem that is hindering you from entering into the transaction. So you, as a prudent lawyer, you are under an obligation to solve the problem so that your client enters into. So the question will be set when it is a sale transaction, but your client has a restriction that restricts him from entering into. So they will require to solve the problem for him so that he enters into that transaction. So the transaction can be sale, lease, mortgage, okay, whatever. Okay, but these restrictions we are going to look at stop you from entering into that transaction. So that takes us basically to what we call legal restrictions. These restrictions are in different laws. Okay, some of them you may fail to allocate them. Okay, but we are going to list them as I'm pointing out the different laws. And then when they are asking this question in orals, they may not tell you that we are testing legal. Sometimes you might be lucky. They tell you, give us 10 legal restrictions, but they can tell you cancel. Assume you are the legal officer of Stanbic Bank Uganda Limited. As a prudent legal officer, what documents would you find on a file for an intending mortgagor? Literally, they are telling you what restrictions or what due diligence are you supposed to make so that you had those things in your workshops, but they are pointing at something. Okay, if not, they will give you a title. Okay, they tell your client wants to buy that land, advise you. But this title is going to have what we call encumbrances. legal restrictions. Look at ownership as you're going to see them, if you know how to interpret a title. Okay, so let's start. The first legal restriction is tenure. The form of tenure in the first place. The tenure itself is a legal restriction. Why? Okay, is a tenure. Okay, who has the RTA? Read section 101. Okay, even if you don't read it, says the proprietor of any mile of freehold, okay, may by a document in the prescribed form, okay, may lease. What does that mean? To enter into this transaction, it is restricted to only to tenures. So now you get it. They'll give you facts where this person wants a lease from my land, but my land is not under freehold or mile. It is customary. So can I enter into that transaction? So how do you solve that problem? You convert from customary to free, which already dealt with. You see, because it had a legal restriction. You've solved the restriction, now you've entered into. That's one. Okay. Then another restriction is under section 38 of the Land Act. Okay. It is known as security of occupancy. Okay. It is also a legal restriction. You can't just wake up and sell and lease and mortgage family land. How? When? Who? Okay. So then, because when you read section 38, it is very clear that no person shall, you see, you are restricted. So it becomes a legal restriction. Those are two. Okay. Then the third one is known as spousal consent. Okay. Spousal consent. That is under section 30. Okay. We have section 39 of the Land Act and then section 5 of the Mortgage Act. Spousal. So you can't sell matrimonial property. You can't lease, you can't mortgage, you can't transfer matrimonial property without consent of the other spouse. So it becomes a legal restriction. Okay. Then another restriction is known as ownership. Okay. Ownership. Ownership. Okay. Ownership. We in the law of contract, we have the principle known as the nemo dat rule. What does that mean? You sell what belongs. So that means if you are not the owner of that land, can you sell, can you lease, can you mortgage? So what happens where Kakai is the owner of land, but he's not around? Okay. Now let's just read some sections to confirm that position. Which law provides for right to mortgage? Section 3 of the Mortgage Act. It says, the owner of any land under any tenure. You get it? So that means if you are not the owner of that land, the general rule is you cannot enter into the transaction of mortgage. So that was my third question in orals. They told me, Rashid, your friend so and so wants to acquire a loan, okay, but he has no security. Give him 2 ways on how he can. Now I knew that the rule is for you to mortgage, you should be the owner. So what is the exemption to that rule? A third party mortgage or a mortgage with powers of. You see, under those, there is a problem that to enter into this transaction, you should be the owner, but you are not the owner. That's the legal restriction of ownership. So if the transaction to enter into is a mortgage, okay, and you are not the owner, how can you enter into that transaction? by going for a third-party mortgage or mortgage with powers of. So you've solved the problem. Then also, in the same regard, when it comes to selling or dealing in anything where you are not the proprietor, which section provides for powers of attorney? In the RTA. Okay, let's go to the RTA 146. Okay, it says, okay, even if you read the law, the section itself, what we are doing, but for the way you read the sections, okay, you read it and you don't get out what is relevant. Okay, it says, okay, the proprietor of any land under the operation of this act. What proprietor means? Ownership. So the owner. So the legal restriction you are looking at is ownership. Okay, or any list. Or mortgage may appoint. Okay, you get it. So this section says, okay, you can go ahead and appoint a third party. So that means they'll give you facts where I'm not around and I'm intending to sell my land. Okay, so what will I do? I'll give this person powers of. So this person will sell for and on my simple tax. Okay, then if not that, we are still okay. When you look at that as well, okay, in the same regard, they will give you facts where land is registered in the names of a minor. Okay, the mother wants to sell because she's a single mother. Okay, she wants to sell this land and construct rentals for this kid. Okay, for the future benefit. But can the mother sell? The mother is not registered. So how do you solve that? You go for guardianship. Then if not, they'll give you facts where the registered proprietor is a person suffering from a mental illness. That person has no capacity to. So what will happen? You go for an order for management of the estate of a person suffering from a mental illness. They'll give you where the registered proprietor is missing. Okay, we need money. Okay, but this person is missing. Okay, so you go for what we call an order to manage the property of a missing person. They're all, but you're going to study those two in third. There are only two things to study in third term. That's why, okay, it has only one, the land. Okay, then also you have another legal restriction. We are still dealing with ownership. Basically, they will give you facts where the registered proprietor passed on, but you want to sell. Can you sell? If you sell when the registered proprietor passed on, it is which offense? Intermeddling with the estate of the deceased. So how will you solve that problem? Getting letters of, so that you can sell something that belongs to. So you see how ownership is a bit wide. Okay, those are legal restrictions. Then another legal restriction is another legal restriction. We have nationality. Nationality. Section 40 of the Land Act. Okay. Okay. Section 40 of the Land Act deals with nationality. You can also refer to Article 237. Land belongs to the citizens of. So if you are not a citizen of Uganda, yes, Article 237. Land belongs to the citizens of Uganda. So if you are not a citizen of Uganda, you can't buy mile, freehold, and customary. You only go for Why? Nationality. Okay? Nationality. Okay? So when you go to Section 40 of the Land Act, it also expounds on the same. Okay? Land, acquisition of land by non-citizens. Okay? So ask yourself, what if you are given facts? Okay? When the person who wants to buy Maya is not a citizen of Uganda. You see, this person is restricted from buying in Maya or freehold because of this citizenship. So how do you solve that? So you either advise him to go for a lease. If not going for a lease, this person will go for establishment of a citizen company. You look at the case of Binzika versus Binzika. Okay? You are still solving legal restrictions you've not yet entered into. Then another legal restriction is what we call encumbrances. Encumbrances. These include caveats and mortgages. Okay? So they'll give you facts where this person is intending to buy land, but this land is subject to a lease, a mortgage, or a caveat. No transaction can take place unless you have written consent of the caveator, the lessor, and the mortgagee. Simple as that. Okay? So, but you see everything we've looked at, they can't ask you that question directly. Never favors that. So what they do, they just give you a title with everything we've been talking about. Registration, you look at the memorial page, look at the Congress page, okay? The conditional page so that you understand these restrictions. Okay? So now, we presume, okay, encumbrances have mortgages, leases, and caveats. Yes. Okay? So now, and a court order is an encumbrance. Okay? So now, we have solved all the legal restrictions. Now, ask yourself, can we enter into a transaction? So which transaction? So that takes us to the first category of our transaction, known as a sale transaction. So that takes us to what we call structuring the sale transaction.
Excuse me, first. But now if you're saying this is an encumbrance, but this person, the mortgagee, can do what? Can mortgage land.
Subject to also that mortgage. So you first agree, it's subject to consent.
Sure. Like you can just get it and then mortgage it and get a loan. It's very bad.
Okay. So whenever land has an encumbrance, every transaction has to take place subject to consent of the person who has lodged that encumbrance. Okay?
What are the policy?
So court order can be an injunction because when an injunction maintains status quo. Okay, you can't transfer that land unless the court order has been lifted. Okay, so now we have solved all the legal, and now please mark this. In your end of term exam, number 1 comes from that area, whether you like it or not. Yes, number 1. Just go home, get the question back. Kebera question is a land is on a question number 1 throughout. You tell me whether you can't answer it. Never after understanding those. All number 1, it always has A, B, and C in most cases, but A will be on a non-citizen, B will be on a minor, then C, they can choose a deceased person. In most cases, if you have a question bank, you can check. You check for 3 years consecutively. You'll tell me whether you're not ready for number 1 at the end of term. Simple as that. Okay? But don't forget, wogenda mu land twala civil ne family. Wogenda mu family twala civil ne land. Wogenda mu civil twala family ne land. Okay. Okay. Intermediate in the Succession Act. Okay, so are we together? So now, after all those legal restrictions, now you are at liberty to start entering into the different transactions. So we said for today, we are looking at one transaction, which is known as a sale. So let us learn to sell someone's land. Okay.
Johnny's land.
So we are going to sell. So we are going to go for what we call structuring of a sale transaction. Okay. So how do we structure a sale transaction? Okay. So this means when we are looking at structuring, you know who the parties, you know how it is performed, that is, and also what happens in breach. Okay. When you are dealing with the structuring, you know who enters into this transaction, how it is performed, okay, and what remedies are available in circumstances of breach. Okay. So now, it is the simplest. Okay. That's what with the list of covered topics. Okay. So now, at this point when we are going to sell, remember the legal restrictions we talked about. Okay. First put it into consideration before you effect a sale. Okay. You can get a title when it's co-ownership, joint ownership. All parties have to consent. You get it? Okay. So now we want to structure this transaction. We are not going to enter into what we call due diligence. Okay. But it's okay. So when we are entering into a sale transaction, before, the first thing we do is due diligence. Okay. Due diligence. Okay. Which law tells you to do due diligence? We have Regulation 12 of the Advocates Professional Conduct Regulations. Okay. Because under the Advocates Act, advocates carry out two types of transactions. That is to say, contentious transactions and non-contentious. Non-contentious are outside court. Those are what we call transactions that we do here, sale of land, mortgage, because we don't go to court. So those are what we call non-contentious business. Okay. So now, when you are dealing with non-contentious business, you have to apply Regulation 12, which is diligently advising your client. So by the duty conferred to an advocate as a result of Regulation 12, what type of due diligence do you do? So we have two types of due diligence. Okay. This is sometimes due diligence is known as search. Okay. So we have what we call physical due diligence and then diligence in the land registry. Okay. Diligence in the land registry. So in the land registry, you are going to be looking for ownership, acreage of land, what and everything. Okay. Then the physical search or the physical due diligence includes visiting of the locus, asking neighbors, okay, who is the owner of this land. Me one day I was on some land for my mom here in Sanga. So it is in town, but it's vacant. We have a garden there. It's the town of Sanga Matunda. So some brokers came. So I was seated under a tree. So so nembabuuza nenzira ebbali. I wanted to see what exactly takes place. Okay. Wonna tutungawo. Naye nga nanyita kawendi. This guy is so cheap. Wonna tukola ki? Omugagga waali tugenda mukubira. So this guy, number number, they must have been number, then I see young. Okay, but because all people around that land, they know that's the owner of that land. Because I come, I have back and around. When I go there, I take them something. You take just 2 kilograms of sugar, bread. So they're like, hey, come on, you come, or you're here. Okay. So now, when I stayed around, so when these guys went, the potential buyer came back. Okay. He called them around and said, ha, remember ngambe ni takabali tu. Nga, usako mukadde wa wali. Yatera okubeera kuno sitera kubeera ko mbale nago nnindirao. So this guy went to Mukadde. And I'm like, omwami oli police oli yenna. And then the guy came back. So nsaba kunsonyiwa twalambudde ettaka lyo naye nga tetukoze eki kyetugambye. So mbadde mbuuza otundawo mmeka ne mubuuza ngaani nga situndawo kuba nze nnindirao. N'akubira ababulooka baagana kwata. Why? Due diligence. Because you see, the issue of buying land, well, that's why when you look at the case of Osman Mato, land is not. Oyinza okwanga n'akakoloti akali ku kkubo ne bakaba 2 ku 2 nkagula njagala kuzimbawo buduuka. So you find that 2 ku 2 n'ogigula cheap million, yes, naye no spending obukadde 4 okutereeza ekya million 4. Okay, why? Because of failure to due diligence. Omusajja yakwata sente nampa emitwalo 10 webale sebo. Okay, ontaasizza. So because the guy was intending to pay over the weekend. Okay, so that's what due diligence. Okay, failure to do due diligence, it is what it turns out what we call fraud. But we shall look at that at a later stage. So when you are entering into this sale transaction, you have to carry out due diligence. What am I going to buy? Okay. Now what happens in Oros? They tell you that they can give you such reports, okay, and the title. Okay. They tell you this is the search that was made, but this is the copy of the title. They put a mistake on the title, okay, which is visible. Now you have to turn this from theory to practice. So what they do, because when you make a search, the search doesn't tell you who is the former registered proprietor. It gives you the current proprietor. So they will give you a title, okay. On the ownership page, okay, they will tell you Rashid wants to buy from Hajat. Okay, this is the title. Okay, so but when I see the title, okay, the title indicates that Hajat was the first registered proprietor. Okay, but Hajat was cancelled out. Okay, and Aisha is the current registered proprietor. But Hajat tells you she bought from Aisha. So you have a certain report, you have a title, and again, standing right next to you see where the problem is. Hajat bought from Aisha, but Aisha is the current registered proprietor. So who is going to give you transfer forms? It should be Aisha. But are you buying from Aisha? So that means Hajat has no powers to transfer. So that means when it comes to that part of performance, because it is performed by signing the transfer forms, that part is not going to be performed. You get it? So that is a form of, so it is an indicator that this transaction has a problem. So that means that is another form of due diligence. You get it from this normal perspective, bring it in a practical way. Okay? If not, on that very point, it has dates this side. They'll give you a date which is a public holiday when it is a Good Friday. And you guys are from Good Friday. Mark the date. Okay? Look at the date when Olanya was buried. It was a working day, not so. Never back to me. What was I doing? Okay. What if I did the title? Now you want to say because we're gonna call alterations. But when you on a pen, okay? But you the date it's a public holiday. Due diligence requires you to know when was this day. Was it so which public office works in a public holiday? So that means that is fraud. This person got registered fraudulently. So once your client enters into that transaction, this person saw the title. The title had a date which was a public holiday. So okay. So that means you knew the fraud and you decided to proceed. So that transaction is wrong. If not, they will put time. They put at your time the public office is open 9. They will give you 7 a.m. Okay. If not, they'll give you at 6 or 5. But the public office they call beyond 4. Okay. The actual time of closing is 4:30. Okay, when it be a family now, the chap at same time 4:30. If you've realized that. Okay, so they'll give you the title was someone was registered at 6. Which public office works at 6? Okay, or late in the night, so the ghost came and printed the title and even signed. So that is, remember that system is automatic. Once you print, the time it comes out like this, the computer is set it on. Okay, so now it's all that is due diligence. So go back what the title. Which kind of due diligence is that? Are you a lawyer? Okay, are you an advocate who is bound by regulation 12? So in all those, don't take your common mind. Think between the boundaries. Whatever document they give you, it can't be okay. It is impossible. Because they give you this transaction, it should have a problem. That's the general rule. There is no transaction without a problem. Okay? Why no visible? Because that means, because I told you, assume there is no client who comes to an advocate without a problem. Impossible. Okay? So go back to facts. Why no visible? Okay, so that you get back to normal. Okay? So all that is due. So we presume that you've done what we call due diligence and everything is okay. Now you enter into. So whatever we've been looking at falls under the first stage, which is known as before. So all of that is done before entering into the transaction. So the presumption is you have solved the legal restriction, you've done the due diligence. Now now this into. So how do you enter into a sale transaction? Is by signing what we call an agreement of sale of land. So ask yourself, do you know how to draft a sale agreement? Okay, so now we want to enter into. Okay, so how do we enter into? We've said we enter into this transaction by, okay, by drafting and signing the sale agreement. So that we will say, or in agreement, your man. Can you draft it? Okay, that one is simple. We have it in our books, not so. We can refer to it. Okay, we can refer to it. Okay.
What terms should it be?
Yes.
What terms should it be in our sale agreement?
The standard sale agreement should have, I think, a maximum of 10. Okay. Okay. Minimum 8. Minimum 8. Maximum. Tosukao. Kati gobo jina mu kitabo kyo. Ngesukao. It's wrong. Okay? Paragraphs, they should be 13. Maximum go one listen no bingi. Okay? And there are things that shouldn't miss in the agreement. Okay? So when you are drafting an agreement, one, an agreement can be used as evidence, not so. That means it's the public, so it should have the Republic of Uganda at the top. Okay? Then remember, it is between two parties. Which law is that? So you said in the matter of the Contracts Act, what are you selling? In the matter of the land. So if your land is not registered, don't include the RPA. Don't include the RPA. Okay? Don't include the RPA or come out. Okay? Then no longer. But where if your land is registered, then you said, and in the matter of the registration of titles acts. Okay? Then the land you are selling, where is it located? Then you say the matter of sale of land comprised in block this, lot this, land at Kaguguve. Okay? So now, after that, okay, who are the parties entering into this transaction? Okay, so this agreement is made between the vendor and the seller. Mark this. Depending on the vendor. Remember the legal restriction we had. Okay, ownership. They will give you where the vendor has powers of. You get it? Where the vendor has powers of. Where the vendor is an administrator. Where the vendor is a guardian. You have to include and show it. Okay, you can say Narubwama Hadija, okay, the lawful attorney of Rashid, the registered proprietor of this land. You get it? If not, you say Narubwama Hadija, the administrator of the estate of the late so and so. Herein after referred to as the vendor. Okay? You say Narubwama Hadija, okay, the lawful guardian of Nantesa so and so, okay, minor, the registered proprietor. That is paramount. Okay? You get it? That is paramount. Also, where the vendor is a company, you should show that the vendor is a registered entity, this and this and this. You have to show the vendor. Then you go to the purchaser. So we've seen the parties. What are they selling? Land. Then you go to what you call description. Sometimes we sell the entire piece of land, sometimes we sell parts. So depending on your facts, if you are selling parts, you say land okay, approximately 20 decimals of land comprised in. So that means on that land, you are selling off only 20 decimals. Okay? You give the description. Then after you've described what you are selling, not so. Why are you selling? You want money, not so. Tell us the consideration. Okay? How much have you agreed upon? Again, on that consideration, depends how you're going to pay. Are you going to pay in installments? How many installments? When? Indicate. Okay? Then after the consideration, what happens after you paid your money? Okay? You need assurance. Then you go to warrant. Okay? The vendor is warranting the purchaser that the vendor warrants that is the lawful owner of land here and here. It has the encumbrance whatsoever. That warrant. Okay? Then after the warrant, now you sure that okay, the land belongs to this gentleman. Okay? After buying, what should you do? You have to take possession. Then you put possession. Who has to give you possession? Then you say, the vendor shall hand over vacant possession, either upon execution of this agreement where you are paying only one installment. But where you're paying different installments, say, upon payment of the final installment. Okay. Then after taking possession, what should be done? The village doesn't know you. They introduce you to the village because remember you need the signature, the chairperson at the later stage when you transfer in land. You get it? Then you say introduction. You say the vendor shall introduce the purchaser to all the relevant local authorities as the new proprietor and owner of the said lands. Then after you have introduced me, depending if I'm selling part of land or the entire piece of land, then we shall go to what we call transfer. He said the vendor shall hand over to the purchaser duly signed transfer forms, okay, and all other related documents. Where you are selling the entire piece of land, but where you're selling part, you say the vendor shall hand over duly signed mutation and consent forms. Because mutation, you send it parts. Okay, you first mutate off, then you transfer. Okay, then after that, what if this person doesn't give you backup position? Okay, what if this guy doesn't pay you the balance? What will happen? Then you go to what we call dispute resolution. What would you negotiate? Would you go to court? So you include how you deal with, okay, how you will settle the same. Then you date and sign. Very simple. Okay. Yes, you get whatever document that is supposed to be signed. You say, I therefore sign. They don't leave a document blank. Era wali okubiyeko document yonna mu exam ne bwe ba plaint ebeerako cancel for the plaint nga walekawo nga tewali sign tofunangayo maaka neeki. They've never told you. Oh, hey, wait for family. You can't survive. They don't. It's incomplete. Okay, assurance. Okay, so are we together? So now let's settle. Okay, so now, okay, so now let us be honest. Have you ever filed the document in court when it's not signed? Now, to be honest, the section, the question says draft the relevant documents for court. So when I was drafting was like a sign it there. You need they never gave you good orientation. So that's the difficulty. Okay? But when you're going for final exams, they will give you orientation on how to write an
After
exam.
I've failed, like
You've not failed. So we go on. So now, what you should note, this type of transaction is performed basically in two ways. How? They can ask you, how does a vendor perform a sale transaction? It is by giving vacant possession and transfer. Okay, that's how they perform. Not so? Then, how does a purchaser perform? By paying purchase price. Okay, and those are the most pertinent terms and conditions in a sale agreement. Okay, so now what happens where there is a breach of those conditions? So that takes us to what we call remedies upon a breach of a sale transaction. Okay, so these remedies are divided into two. We have short-term and long-term remedies. So now, some people yesterday didn't understand that we had to first discuss short-term remedies and then long-term remedies. Okay? Well, the actually about the come upstairs. Just remedies. You have to break it into. When I was issues big, you pass the eye. You have to think. One cancer that tells you. Don't use question-ended questions, but you fail. Someone said, what are the available remedies? Then after, what are the necessary documents? Issues. You have to say, what are the interim remedies? That's one issue. Then 2, what are the long-term remedies available? Then 3, what is the forum and procedure for obtaining the above? Then 4, what are the necessary documents? Okay, because Chikwa is of discussing, right? So now, when we are here, we are dealing with remedies. Okay, so we have remedies where it is the vendor in breach. Let's assume the purchaser has performed his obligation, has paid full purchase price, okay? But the vendor partly performed. How? By giving him possession. But this person has not transferred, okay, the land. What remedy is available? Vesting order. Okay? Under which section? 167. That's what we call vesting order upon full payment. Okay, it is for the purchaser. Okay, then what happens where you are not given vacant possession and transfer? This person has not performed anything, okay, on the contract. So you sue for breach of contract, seeking for a remedy of specific performance. Okay. Okay. It's purchase as well. Okay. It's a remedy for a purchaser. You don't have transfer, you don't have possession. They face those problems. They send us money. We also have problems. Okay.
Now this one only applies.
We shall interchange.
This one only applies where there is possession.
But vesting order where you are in possession. But that our possession about specific performance. Okay. Yes, full payment and in possession. That's when you go for a vesting order. Okay. So we've seen 2 remedies. But you know, someone who you've instituted a suit, but when will that suit be determined? It will take time. But during that period, you never know. This guy may sell, or he may construct a house in that land. So what you do, you first go for what we call a temporary injunction. Okay? So we are listing the remedies. Temporary injunction. Okay? We've said you've instituted a suit. Okay? You've instituted a suit. Okay? For breach of contract. But that suit, it will take time to be determined. Okay? It will take time to be determined. Not so? But as a result of that, you need time. But that land may be sold. So you make an application for a temporary. That's another remedy. But also this temporary action depends on the urgency or the wisdom of the vendor. Okay? We have vendors, let me tell you. There is so when it comes to remedies, you have to think first. Okay? You say these questions we are doing here. I saw your vendors trial advocacy. Organize some professional conduct. Bakugambe see attachment way. Now what you play it? Okay? Yes, ojabenti fraud. Nga mwali mu orders wano wansi na temuli mu permanent injunction. Kati jiki ya watu ofisi permanent injunction. Osobola kufuna temporary. Ngoli mu professional conduct. Bakugamba advise your client. kati kino kikolawo. Regulation 12 diligently advise you. If not, bagikuwe nga bakuwe plaint nga temuli facts constitute a cause of action. Is that a prudent lawyer? Bagikuwe nga teri mu jurisdictions. Naye oba olina kulowooza naye nga constitute endabaddewo. But it comes back to this. Bagikuwe nga ya land nga ya fraud nga tekuli commissioner land registration. Okay? But it comes back here in land. You can survive the backwards. Okay? So now we've looked at those remedies. Okay? We've looked at temporary injunction, looked at the interim injunction. Okay? We've looked at specific performance. Okay? So now we have also specific performance applies in different circumstances. Okay? They can give you where Hajat paid half purchase price. She has the balance. But Muslim has seen a potential buyer. Gamu is a Hajat times 2. Hajat Nagam, other sentence. Sikumani Nakwigana. So Hajat comes to you, counsel. Okay? So you start discussing. Hajat is did what type of payment? Partial payment. We looked at equitable. What interest is Hajat having in land? So how does she, what remedy does she have? The first remedy to protect her interest. So that takes us what we call caveat as a remedy. So now, Hajat has lodged the caveat on this land. That means this potential buyer can't buy because of the caveat. Okay? So now, after Hajat lodging the caveat, Hajat Afgamanzereta can be Silibako. So we have to enforce this person to get the money. Why? Under the law, okay, you are only entitled to demand for the balance. Okay? So we go for an order with specific performance as well. Okay? So that means in your plate, you can make even pray for an order of payment in court. Was taken court, will come out of the sector court order. Simple as that. So now you see, we've dealt with entering into, during, and after. After Balaga remedies, what does that mean? The transaction will be complete, but you will have a problem. Which problem? Part payment. Not transferring. You're not in possession. Okay? This person doesn't want to give you transfer. Such things. So what is said with this? We are done with the sale transaction. Okay, yes.
When this person cannot rescind the contract.
Backward facts in the plan, they are yes. So go for rescission.
No, what I mean.
Okay.
Right to rescind.
No, that right is there. But if you are a lawyer, that's not a right.
Yes,
okay.
Now, suppose you don't have that man at that particular time. Are you considered? You the purchase.
The purchase.
Yes, that's what
osigana equitable interest yo. Either mugambo ogenda kutunda nesije tugabanira wakati. Hey, yo. Okay? That's how banks do. Tunda kai tugabane. Bwataka tukutundi. So, we are done with the sale transaction. Okay? So, what was hard? Okay, so we are left with mortgages, leases, condominium. Okay, yes. I remember that. Okay,
So let's go through this.
so that was our coverage for today. Okay, so we want to go through like at least 30 oral questions and we see. Okay, so that at least you can see. Can I apply these principles when they ask me a question? Okay? And it's because what we want right now is basically understanding the law. Applicability of the law. Okay? Yes, counsel? They are the same remedies. That's why we said remedies in land transactions. Okay? So now, as we are getting the questions I want to read for you these topics. You see how we move. Okay? But if you sit alone, you will see how things happen. Okay? Yes, answer. Members, let's listen, okay? Okay? Send him a notice of intention to sue. You sue him for breach of contract, you get an order from court either to sell or to refund. Now, all the land without a title is taken to be customary land. So just convert. But sometimes, let me tell you, it's hard to tell. Okay? Some lands that is always there that people think has the titles. You know what happens? Process waba we yagitandikako nga ina we yakoma. Yes? Aha. Why? Because the current system, by the time they started on that process, this system was not there. But that land is there. You go to Karamazo in Entebbe. You'll get the process where it ended. So you reactivate it with the current. Karamazo. You can. It's because it's a public office. But you need a connection. Because they rarely give you that information. It is there. That's why the surveyor should do that. Only yaba ategedde okukola ki agamba twagenda ewakiso eririyo netugenda ku Ministry of Land zitiriyo kati n'amanya oke tebalina magezi gagenda wa kati bw'ogenda ku Karamazo. You see this, the entire Wandegeya, the entire map of Wandegeya is there. The entire map, every plot in Wandegeya is mapped. Okay? Yes? Yes. No, what happened? That's what for now ratification. But I gave that an example because one, the challenge is we had not occupied that land for 10 years. And this person had already made developments. And the other plot where our title was reading, okay, we didn't want to be like Father Begumisa. You read that case? Father Begumisa bought land. He occupied some land which doesn't belong to him. The guy constructed his dream house and he occupied the house. So the owners came telling him, Msumba, bino byansikiwa ettaka. Tumanaga ettaka lyange nnina n'ekyapa. Kati father akola ensobi addayo ekyapa. Bagenda mu court. Citing section 59. Bagistinga locus. Bagenda okukwata boundary ey'oku kyapa. Nga ng'amazima Musumba tazimbanga. Now eri nkalu. Okay. So they told him either situlingire wano ng'abantu bakulu. So Musumba had to compensate these people because he occupied, but era kyava ku musabeya yakola ensobi. So that thing when Nachira Mkananga no leave it. Okay, because it will cause issues. So did she die? She didn't. So we are living in a very simple, harmonious way. Okay? So now let's read these topics. You also tell that we've covered this topic. It says, okay, 1, identify topic 1. So these are the subtopics. So when you saw the people, you tell me, okay, 1, identification of interest in land and rights accruing therefrom. Have we talked about them? Then another one, classification of interest, i.e. legal and equitable interests. Then protection of interest in land. Certificates of titles evidencing interest in land. Then acquisition of certificate of customary ownership, procedure, bodies and documents. Interpretation of entries on a certificate of title, meaning and legal implications.
Meaning,
Yeah. As I sure. I've done it. When Bagani is a title, check at the encumbrance page, conditional page, you look at the date first. That's what I've been doing. But the challenge is you need titles. The later on, I will interpret them for you. So get a list certificate, mile and freehold. I'll interpret them. Okay. Then another one, okay, land tenure systems. We looked at them. Then another one, conversion of tenures. We looked at them. Dealings in land and due diligence. We looked at it. Okay. Then all restrictions in dealings in land, e.g., citizenship, minority, insanity, family and matrimonial land, tenants by occupancy, dealings in land, structuring of a sale of land and other transactions. Okay. Breach of contract of sale of land and remedies generally for the aggrieved parties, e.g., specific performance. Okay. Specific performance, suit for purchase price, vesting orders, caveats, and then interim remedies. Okay. Then caveats as encumbrances on land. Then transfer and transmission of land. Okay. That one is a transaction. It's a transaction, what you call fraud, because it happens in transfer. But we talked about transmission. Okay. We talked about transmission. Are you sure we didn't talk about it?
we didn't.
We didn't.
Yes.
Did you talk about letters of administration in land? Did you talk about letters of administration in land? That is what we call transmission.
Okay.
Okay. Then another one, agency in land transactions, powers of attorney, how they are executed, attestation, and their implementation. We talked about it. Then co-ownership, joint tenants, tenants in common. Okay. We haven't. Okay. Then ethical considerations. So you see, you can cover this one topic just within but like the tomorrow. You see how you will read it. Okay. So we've not covered co-ownership, okay, which is joint tenants and tenants in common. That's what we've not covered. Okay. Joint tenants, tenants in common. Did I talk about it anywhere? Did I talk about it anywhere? Okay. I did. Under legal restrictions, not so? So, is land hard? Just the way we read. Okay? So before we do this question, I want us to agree on the time we are starting tomorrow. Okay? Okay? So should we first deal with land?
Yes.
Or we get another course in it? Members, listen. Members, listen, okay? Order. Okay? By raise of hands, we are voting. And the voting is by special resolution. The special resolution under section 78 of the Companies Act is by the majority of 75%. We have people online, they're also going to Both. One. Just
Before you go, I feel we pass this on because she had a valid point. That's a great
okay.
She had a valid
Members, listen. Answer all the questions. Oral questions. So let's first deal with the questions. Someone with the questions back for orals. Someone with the question back for orals. So let's first do these questions. I'm choosing random. I have those who are online and who are here. Okay. So I'm choosing randomly. Okay. Randomly. Don't worry. Yeah. You know what I hate most here? When you look at the first page, there's a number is the voices during the discussion. Okay, let's go. Okay. Let me start with those who are online. Okay. Council unmute your Veronica, kindly unmute. The first question comes to you. You've unmuted. Council Veronica, kindly unmute. Thank you. Question one.
I'm here, Council.
Okay. Council.
Yes.
Question one. You are the registrar of titles of Wakiso. Okay.
Yes.
That should not the caveat under registration instrument number WK 006421. Okay.
Yes.
Aisha intends to transfer the same land. Proceed. You are the registrar of titles Wakiso. Okay. Rashid registered a caveat on a particular piece of land under registration instrument number WK005241. Aisha wants to effect a transfer on that land. Proceed. I'm not asking this question, but I said it should be changed. Okay. Council, proceed. Council, proceed.
Yes. We shall pass. I think we shall first start by defining a caveat.
Council, you and who?
I will proceed by defining a caveat.
Council, you are a registrar of titles. You are a registrar of titles. I repeat my question.
Yes.
You are the registrar of titles Wakiso. Rashid registered a caveat on a certain piece of land under instrument number WK00421. Aisha wants to effect a transfer on that land. Proceed.
As the registrar, when Aisha comes to me, I shall call Rashid to show cause why Aisha should not be transferred to the land.
So council, you give Rashid a phone call, eh?
I shall.
Notify us how, okay?
Yes, I shall.
Council, I've given you the answer. I've said notify us. So the answer is I'll issue a notice to show cause.
Put upon notice.
Okay, so they're asking, once a caveat is lodged, what is the deed of the register of titles? So once any transaction is going to take place, the registrar has to notify the caveator by issuing a notice to show cause. That's why I was directing our council. Are you going to give Rashid a phone call or you will notify him? So if I'm telling you, you don't call him, you issue him a notice. So on the word notify, cut the SI as a notice. That's how orals are. Okay.
So that means
yes, again they will ask you how. Okay. That means they want you to say that exact word. Notice to show cause why the caveat should not be vacated. Okay, council, thank you. Okay, council Mwange Arafat, kindly unmute your microphone. The next question is yours. Okay. 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 Differentiate between a lawful occupant and a bona fide occupant.
Okay, thank you. A lawful occupant is a person that is living on a certain piece of land where there is a landlord with knowledge of the landlord. So basically, a lawful occupant lives on occupied.
Okay.
A lawful occupant lives on land of a landlord with his or her consent or knowledge. Basically, these are people having equitable interests on a land, but where they have been in occupation of that piece of land with consent or the landlord knows about them. And also the Land Act defines them to be people that have been living on a certain piece of land as a result.
Listen, okay? We are still in class, okay?
As a result of the what are they called? Busulu and the Mvuju laws, then the Toro Agreement, Bunyoro Agreement, I've forgotten the years. Then a bona fide occupant. These are people that have been settled on a certain piece of land that is 12 years back before coming into force of the 1995 Constitution. And also people that have been occupying land, let's say people that have taken adverse possession, they have been living on a land unchallenged for a period that is 12 years or more. Yeah.
Okay. Thank you. Okay. Then another question. Council Gibbs, kindly unmute.
You sure I am on the call?
Yes. Yes. Okay. What are the vital features of a court? Court means certificate of title. What are the valid features, the vital features of a certificate of title? The vital features of a certificate of title.
Thank you, Council. Certificate of title
One
should have one location of the property.
Location of the property.
The property.
Yes.
Two, should have the proprietorship of the property.
Proprietorship, yes.
Three, it should have the instrument number and time when that instrument was entered.
Okay.
Three, it should show whether there are any encumbrances to that title.
Okay. That's the encumbrance page.
Encumbrance page. And five, it should be able to show whether the title is freehold, customary, or leasehold title.
It's tenure,
It's tenure. You said five, so sir, I'm at five.
Okay, you can also include what you call a deed plan.
It should have a deed plan as well.
Description, yes, deed plan. Okay, then also you can include what you call a conditional page in some titles. Conditional page. Thank you, Council. Council Michael Kanyamunyu, kindly unmute the microphone. Kindly, Council, unmute. Okay, thank you. What do you understand by the term EMZO?
The term what?
Understand by the term EMZO? Members, please.
What's the spelling of that word?
What do you understand by the term EMZO?
What's the spelling of that word?
MZO.
MZO.
Yes, Council. Okay, the term is Ministry Zonal Office. So that question always starts with a follow-up question. They tell you, give us 5 offices. You know, five Ministry Zonal Offices, you know. Council, proceed.
Ministry Zonal.
Yes.
So in this case, they want their location or?
The places where those offices are located. Okay. So, one, we have Wakiso Chadondo. Okay. That's one. Okay. We have Wakiso Chadondo. That's one. Okay. Then we have Wakiso Busiro. Wakiso Zilies. Okay. We have Wakiso Chadondo, Wakiso Busiro. Okay. We have Bukalasa. Okay. We have Impiji. We have Mukono. We have Mitiana. Now, you may think that each district has a zonal office. No. They are regional. Okay? You get it? So we have Kampala Zonal Office, that is KCCA. Okay? Kampala Ministry Zonal Office. Okay? We have Masaka. We have Mbarara. We have Jinja, actually, some parts of Jinja are subscribing to Mukono. But after the developments, Jinja na area funa. Okay? Mukono had. So you get it. So you should be aware that, for example, Nakasongola, okay, subscribes to Bukalasa. Nakaseke, all of Bukalasa. So we have Entebbe, Kajansi, all that is Wakiso. That is a land office in Kuru. Okay. So mark that. That's what the question required to answer. Okay. Who else? Let's test from here as well. Okay. Okay. Yeah. They share. Okay. Now. Okay. These are test suits. These are test suits. Aisha. Yeah. Okay. Your question. Okay. Your question. List. Okay. List 5 registrable instruments. That's why I give this question. Okay, that's R1. Mark this. They have said, okay, give us 10 instruments. Minimum instruments that are registering as a mortgage, a sale agreement. We don't register it. Okay. A gift deed we don't, but it's an instrument. But I've listed what we call registrable instruments. Okay, katigosobola okubeeri n'ogitomera ng'olaba ogikola ki when they are restricted to only those that can be registered. I shall proceed one. Mortgage deed, lease, caveats, letters of administration, letters of credit, Do they appear on the title? They don't. Registered. Then the last one is a court order. Okay? It is registered. It appears. That's how people fight nowadays. Because court caveat has Jacob. Is a much cause. Court order, a na court order. It has already funa. And I'm okay and so on. Na court order. Osobola osiba ettaka ly'omuntu emyaka aga 2 kala akunoonya. Yes. Okay, the court order. Okay. Then yes. So it is yes. Okay. Okay. So when you look at these questions, most of them we've already covered them. Okay. We need to get something different. Okay. So tomorrow we shall start at, let's start at 9. Okay. We shall start at 9 up lunch time. Okay. We shall start at 9 up lunch time. Okay. We shall start at 8. Okay. Then listen. Okay. Listen. We shall start at 8. We end at midday. Okay. Yes, at midday. So that is the question. We'll finish. Okay. Okay. Members, listen. Okay, members, listen. Okay, we are going to deal with leases and mortgages. Okay. Okay. Monday. So land is scheduled to land. Okay. But mortgage just have to get loans areas of big. Then Monday we are dealing with corporate and commercial. No, what none of Mr. Monday. Yes. So let me wish you the best. Let's meet tomorrow.